Amen.
From Minister Dana Dixon, also Senator Donna Scott Motley, who they're occupied elsewhere. I know Ms. Sandy Lou Coljart, she'll be here shortly. She just said traffic has held her up a bit, but she will be here almost in another few minutes. Let me welcome Minister Juliet Flynn, Cuthbert Flynn. Right. Now, I think there are no other apologies from...
Possibly have Member Hamilton, she said that she will try.
And join online.
No, well, not online. Well, I don't know if it's online or in person, but if she doesn't show up, we'll just have to...
All right. So we're going to begin and welcome everyone. This is another meeting of the Joint Select Committee to look at the matrix, and really what we're hoping when we get there is that we can move through as quickly as possible. Some decisions we have to make, but before we get to the matrix and look at all of the recommendations and what we accept and what we don't accept, we're going to ask that the minutes, what minutes are available this month? April 22nd, is that the only minute that is outstanding? How many other minutes is there?
Including this meeting,
Well,
what we can do is that we want to confirm them as it stands for the remainder of this session, because the session is not complete. It is that we can always confirm them in September, or we can do it in August.
Right. Well, it's clear that you know, we are trying to get a report to Parliament, you know, in due course. We were hoping to meet tomorrow, but Minister Grange begged if we could give her tomorrow. She has some domestic violence matter to deal with tomorrow. So I agreed, but if we don't finish today, we have to start looking at another time. But the problem with looking at another time, Mr. Nash, our secretary, is saying that there are about 3 other minutes plus today's minutes. And the next meeting, I really want to be the final meeting, where we do. But will the minutes be ready? You see. But let us see if we can finish up today and how much more remain. All right, so I don't know, Donovan and, Minister Williams and Senator Shireen, the minutes, I know you're online. We are going to ask for confirmation of the minutes. Are there any corrections to the minutes? If not, can I have someone move for the adoption of the minutes of April the 22nd? On the record, Minister, sorry, go ahead. Minister Dalrympe Filbert has removed his confirmation. You'll second it, and Minister Juliet Flynn will second. If there are no matters arising, we have Shanique and Venetia. Would you be able to begin before Sandy comes? All right. So could you just remind us where we stopped last time so we can move there?
Good morning, everyone. We stopped at section 15, so we're supposed to continue starting section 16, but going through the new process of the actual matrix for each recommendation. Page 34 of the matrix.
So we're at page 34. And the matrix, there are 2 parts, right?
There are 2 parts. We're on part 2, I think it is. Part 2?
So we're at 34 and part 2?
Yes, page 34, 58. Mr. Nash, that's part 2, right? Yes, part 2 is, goes to 58. Daniel Barnes, diversion options, section 16, 34. Daniel Barnes, Ministry of, yes.
Just let me be sure that.
34. Section 16, diversion options.
So let me just consistency. Page 34 on that matrix is the one that with Daniel Barnes
Daniel.
right up to Michelle McCullough.
Yes,
That's,
Minister.
is that number one? Is that matrix 1 or 2?
Matrix 2, I have it as Minister.
That's matrix 2.
Yeah.
What about matrix 1? Where are we on matrix 1? What page?
So matrix one, so part one.
Shanique.
Which one is your part two?
Well, part 1 would have been the one with Free Children Foundation. That's
Yes.
what you have.
Hold on. No, part one is Daniel Barnes.
Oh, part 1 is Daniel Barnes. Okay.
Oh, that's part 1.
So this is
So part 1 is Daniel Barnes.
Okay, so and part 2 is. Okay.
Minister,
Yes.
just a housekeeping matter, a request if I could put it on the record in this committee. I have said it elsewhere to parliamentary team before, but when the matrices are produced, would Parliament be kind enough to title it according to the version? Because sometimes we have several versions of a matrix that's produced and they all have the same title. It becomes a little difficult when you have the paper after some time to figure out which one you have. If they could just title the matrix version 1 or date it so that we know that we are actually looking at the most recent copy. I'm not having a difficulty this morning, but
Right.
I have in the past.
All right, so just as I understand it, so we are consistent. Part 1 is the one that starts out with Free Children Foundation, okay? And part 2 is the one with Daniel Barnes.
The other way around.
No. So you have part 1 there. So you're mixing me up.
No, I see what happened.
No, 1 second.
No, I see what happened.
All right. No, I'm now being corrected. Part 1 is the one that starts with Daniel
Daniel
Barnes.
Barnes, yes. Is
Right.
Part 2.
Yes.
Right. You see the difficulty now, Minister?
Well, I understand. That's why I wanted to be consistent. All right. So, Shanique, you wanted us to go to part 1,
Page
Page-
34.
page 34. One
Section
second. So, part
16.
1, page 34. And part 1, remember, is the one with Daniel Barnes at the front. Page 34.
Diversion options.
What about part 2? Where are we on part 2?
Okay. Yeah. So we'll be at page 20. So we'll be at page 20, Minister, in the part 2,
Part 2, we're at page 20.
which would be the same section 16,
Same section 15.
diversion option.
All right, so who's going to take us now? You, Shanique, or?
I will start and
Ms.
allow
Mayor.
Mrs. Koljar to settle down.
All right, well, proceed now.
Have we all found the page?
Page, what you said again?
34 of part 1, which Daniel Barnes, and page 20 of the other one that starts with Fiwi Children Foundation.
And that's section?
Section,
Page 20?
page 20, Minister, for section 16. Yes, Minister.
No, but part 2, we're at
Yeah, I have it as page 23.
page 23. For section
Yes.
15.
Next one.
Part 2, I have as page 20. One moment.
No, it's 23 for me and
No, diversion.
page 23 for me and part 2. Section 15. Minimum standards of child diversion.
I stand corrected. I am told it's page 23 for the FIWI. Yes.
All right. Shani, go through
Daniel
page
Barnes.
15.
Okay.
I mean, section 15.
All right, so you're going to read the section of that one? All right, Minister, we are ready.
You're going to summarize the recommendations, please, rather than reading them. Okay.
If I may, Minister, I think from the last discussion, we were saying that we would need to read them verbatim so that the committee could say yes or no to each suggestion, because that is how it
All right,
is
go
to be
ahead quickly.
recorded.
Go ahead.
Right, so I would first have to actually read the section and then read the stakeholder comments. So the section of the
By
Act,
one.
which is section 15, and then we would proceed to read the stakeholder comments on that section. So I will start by reading section 15 of the Act. So section 15 of the Act speaks about minimum standards for child diversion program. So a child diversion program developed under section 14 shall be developed, administered, and supervised so that the best interests of the child are the paramount consideration. B, take into account the public interest. C, utilize a restorative justice program approach. D, be developed with a view to causing the child to understand the impact of the child's behavior on others, including the victim. E, taking into account the child's socialization needs. F, be delivered in a location readily accessible to the child. G, be capable of being administered in various locations, circumstances, and for a number of diversion offenses. H, be structured in a manner that enables 1, proper supervision of the child participating in the child diversion program, and 2, evaluation of the effectiveness of the child diversion program by the child diversion committee. F, be developed to take into account the needs of children in rural areas or remote areas in the parish. And J, promote the involvement of parents and guardians as appropriate. So that's section 15. So we will now look at the stakeholder comments that we would have received on section 15. And then the committee would be asked to say yes or no in agreement to possibly considering each stakeholder's comments for the or towards the amendment of the Act.
The first recommendation we had from the Ministry of National Security and Peace, it said additional provisions may therefore be required to ensure that diversion programs are accessible and that appropriate specialized assessment and interventions are available to children with disabilities.
This is at page 32. Huh?
Of part 1.
Daniel Barnes.
The one that starts with Daniel Barnes.
So I will definitely adopt. No,
Yes.
Ministry of National Security.
It's a broad framework, you know,
34.
special interventions.
Yes.
It's at page 32.
So we're starting at section 15, Minister, page 32.
All right, so Minister, go ahead with Jamaica Coalition for Healthy Society.
Jamaica Coalition for a Healthy Society recommended it is being proposed to encourage young people to go to church and to get involved with supervised activities, encourage parents to play a greater role.
We support that totally. But that's not a matter for child diversion. We will tell parents and churches to, you know, do that. Go ahead.
Ministry of Education, Skills, Youth and Information. In regards to section 15, it is recommended that the minimum standard include a psychological and educational needs assessment as a mandatory component. This assessment should be conducted by a psychologist or other qualified individual supported by the state and completed prior to the finalization of the individual child diversion program. Such an approach would ensure that diversion plans are individualized, evidence-informed, and responsive to underlying causes of offending behavior. This recommendation is also directly aligned with the ministry's ongoing work in advancing school-based mental health frameworks and psychological support system. We are of the view that integrating structured assessment into the statutory diversion process would strengthen outcome and promote more sustainable
This is already been done, okay? So adopted. It's already been done. Next one.
Jamaica Psychological Society. It is recommended that the following be added to the list in section 15. Utilize a trauma-informed approach to enhance the inclusion of such an approach in the development and implementation of the child diversion program.
I don't know, colleagues, what is meant by a trauma-informed approach. Can you
Ms. Clark can speak to that, Minister, but as far as we're aware, it's already been done. It may not be specifically stated in that way in the Act.
So that is being done?
It is being done.
So we adopt it as already been done?
As already
being
done.
Next.
We move to section 16. Oh.
Minister, before we move to section 16, can we just indicate where in the Act that is set out, taking a trauma-informed approach?
Is it in the Act or is it just in practice? Is it, Mr. Scott, is it being done? Is it in the Act, somewhere in the Act that you adopt that approach? We're doing that approach, or it is just by practice?
It's by practice.
The question is...
So the Act stipulates that they should get psychological support, and part of that is that we do...
A trauma-based support?
Yes.
So, but the Act says a psychological assessment.
So all the children that come in, they get what we call an adverse childhood experience assessment that is done to help us to understand, you know, if they've experienced trauma. A part of our intake assessment as well, that is included.
Okay. Is that okay, Senator Golden Campbell?
Yeah. That's fine for me, Chair, in terms of it being an administrative matter. I assume that the Ministry of Education is asking that the words actually be included in the Act.
Well, in the Act, it speaks of psychological assessment. I don't know if you want to, Ministry of Education, would you want it broader than that? It just speaks of a psychological assessment, which would include the trauma-based.
May I please, Minister?
Go ahead, Minister Williams.
Yeah, but it wouldn't hurt, in my view, to add the education aspect to the psychological wording. So it could, for completeness, the psychological and education needs assessment. I mean, it really doesn't hurt to, even if it is done in practice, it could, in my view, be
it's not educational, it's a psychological society was put in that it should be trauma-based. Go ahead, Ministry of Education.
Yeah.
Go ahead, Ministry of Education.
No. Good morning, everyone. So the writing is actually psychosocial and not psychological. So
if we put psychosocial, it would cover that.
Yes.
Mr. Eaton, bear that in mind. Instead of psychological, we put psychosocial assessment.
No,
okay.
It already has. Is it that she's saying it already states psychosocial?
No, it says psychological.
Psychological.
So the recommendation is that we change psychological to psychosocial, which would then include trauma-based. Sorry, go ahead.
Okay.
If you look under section 16 of the Act that outlines the diversion options, under J it would say, as a diversion option, the child to attend counseling or therapy sessions with an approved counselor or an approved psychologist. That is what it says as a part of the options for diversion. So it doesn't say a trauma-informed. It says that as an option in developing the child diversion program for that specific child, the child could attend counseling or therapy sessions with a counselor or an approved psychologist.
No, what is being suggested, however, is that they get instead of a psychological assessment, where does it say psychological assessment?
So, Minister, just for clarity, so once you're doing human services, social services overall, the approach is that you make an assessment and you always believe that what happened or what contributed to this person being here. A part of that is the trauma-informed care that is provided. So it is already a part of what is being done. So whether it says psychological or it says psychosocial, the important component is that it is already built into the intervention that is there.
I think what the psychological society is saying is that just for clarity, it would be nice to just put it in the act, a psychosocial assessment. No. What is, just remind Minister Cuthbert Flynn what is in the act. Read again for me, Ms. Coulthard.
Minister, before she reads that, can I just for clarity, the recommendation that is being made by the Psychological Society is in relation to Section 15, which deals with what the child diversion program developed should take into account, minimum standards. And so what I understand them to be saying is that language indicating trauma-informed approach be included in the minimum standards, the list of minimum standards that we have outlined in Section 15. So while it may be done, they're saying it should be it should be put into the Act in Section 15 minimum standards. I don't have a disagreement with that.
Could we just, I have no difficulty. Ms. Eaton, could you just, maybe we put it as, instead of J, finishing at J, we put a K, psychosocial assessment. Because the psychosocial assessment would include
social
trauma-based.
factors.
Huh?
Taking social factors, things that are happening in the environment, education, other issues that the child may have, not only the psychological aspect.
Psychosocial.
Right.
Right. So, Ms. Eaton,
And that, Minister, is sort of dealt with under paragraph E. So maybe paragraph E's language could just be adjusted to include that in a specific way.
right. So if you, what E says, take into account the child's socialization needs. So to the extent, Ms. Eaton, or drafter, we could just readjust that to reflect what the recommendation of the Psychological Society and the Ministry of Education. The Ministry of Education is saying if we use the term psychosocial needs, then it may cover. Ms. Eaton, you could touch base with education to see whether that covers trauma-based. Okay? All right, continue.
All right, so that is the extent of the comments on the Section 15. So I'll now proceed to reading Section 16, and then we will see what the stakeholders would have commented on Section 16. So Section 16 reads, Child diversion options. 16.1, subject to the provisions of this Act, a child diversion program may direct or require a child to do one or more of the following: to make an oral or written apology to a specified person or institution under the supervision of a specified person. B, to attend a school for the specified period of time, under the supervision of a specified person. C, to accept the supervision and guidance of a mentor or peer in the manner set out. Oh, I'm sorry, Minister. So we're reading this section of the Act. So the Child Diversion Act. Yes. Apologies, yes.
Colleagues, as we go through it, I think it would make good sense for us to have the Act in front of you. I know, but it's because we're not clause 15, and so what is being suggested are what can be added or subtracted from each section or amended. So what in section 15, as pointed out by Senator Golden Campbell, clause 15E, the adjustment there to embrace the suggestion of the psychologist could be there. Okay? All right, so we're continuing, Ms.
Right, so for the committee members, I'm reading the Child Diversion Act, Section 16.
So we're now at Section 16. I continue now, and we're at page 34 of and of Part 1 and 23 of Part 2. Go ahead.
So I'm picking up at D. So 16(1)D, to report to a specified person at such time and place as is specified in the child diversion program. E, to spend a specified number of hours with the child's family members at such place for such time or for such activities as may be specified. F, to associate with persons or peers who it is believed can contribute to improvement in the child's behavior. G, to refrain from associating with persons or peers.
Well, I don't really think you need to read out of that section. Go into the recommendations. Because everyone should have their act before them, all right?
Okay.
Go ahead with the recommendations.
Recommendation for Mr. Daniel Barnes. It is proposed that to amend Section 16 to add the following mandatory provision. A psychological screening assessment shall be conducted for every child entering the diversion program within 14 days of referral. For children identified as having experienced trauma or presenting with mental health concerns, the assessment shall be conducted by a registered psychologist, and an individualized treatment plan shall be developed and reviewed every 90 days. That's his first recommendation.
Well, he also...
Isn't that already covered through you, Mr. Chair?
Well, clearly, that's covered by 15 by the recommendation just
yes, on the psychological, yes.
Yeah. But his second recommendation, go ahead with the second recommendation.
His second recommendation, amend Section 16(1), insert immediately after paragraph J the following new paragraph. K, to participate in a cybersecurity education program addressing responsible use of social media and digital platforms, the legal and personal consequences of cyberbullying and online harassment, digital literacy, online privacy, and respectful online communication, and such other topics as may be prescribed.
No, I must admit, this would be an extreme burden on the Child Diversion Office. So although it sounds, good, colleagues, you see what is being proposed by Mr. Barnes for a cyber security education program.
It struck me as having some merit, some value. The question, though, as you rightly says, is what resources, what would it require?
No, but Minister Williams...
Can it be done as part of the ordinary approach, where at least some sensitization, especially if, let's say, for example, there is some relatedness. Terms of
Minister Williams, I'm going to education. One second. Ministry of Education, may I just say this is something that should be done in the schools, okay? Yes.
FSA. We are from the CPFSA, even though Minister of Education is our parent ministry.
Sorry?
There are no members from the Ministry of Education here at present, Minister.
Right, representing the Ministry of Education.
Precisely, Minister. In terms of the cyber program being purported, it would be to what degree? Because if you, through the assessment, have a child who has intellectual disability or have, from the educational assessment, is have illiteracy, etc., how would this program ties in with what the child needs?
May I just say, I don't think we could put this in the act, okay?
No, No,
So we're not going to accept
No.
the second part of his recommendation, okay?
indeed.
All right, continue.
Ministry of National Security and Peace. Consideration may be given to expanding diversion programs to include 1, counseling and family therapy, mentorship and life skills program, sports and recreational activities, restorative justice processes, substance abuse education and treatment programs, parenting support programs, educational support and literacy programs, conflict resolution and anger management programs, music and cultural arts therapy, and technology-based education and vocational training.
All of this has been done. I know, right? No, wait, but you know, the matrix put out a lot of things which basically are being done. But it's there, so but all of that is done in the child diversion program, okay? Adopt it. We adopt as it exists. Right.
Continuing with the Ministry of National Security and Peace, it is recommended that legislative provisions be considered to allow the court to issue parenting orders requiring parents or guardians of children placed in diversion programs, as well as children on remand or subject to correctional orders, to participate in approved parenting programs and counseling sessions. Additionally, additional provisions may therefore be required to ensure that diversion programs are accessible and the appropriate specialized assessment and interventions are available for children with disabilities.
This to my mind would be something that I'm not too sure that we should put that in the legislation. The point there is that in cases that require, then, you know, the matter could be brought to the attention of the court. And bear in mind, we are trying to avoid taking the child to court. So in a matter like this, I'm not too sure. Remember, we're trying to move away from the child being involved with the court system. This would almost be requiring the child and the parent to go to court. So I don't think we should adopt this recommendation at this time. Go ahead.
Ministry of Justice and Constitutional Affairs. We're at page 34, Minister.
Or 35.
34.
All right, go ahead.
Consideration is to be given to reviewing the provisions to clarify the distinction in the references between specified persons and specified victim. Consideration should be given to including, as a diversion option, mediation between child and the victim. This option is included in the Canadian model.
This is something which clearly is appropriate, but I'm not too sure we need to put that in should we put that in? Is it in the Canadian legislation you're saying?
Minister, that reference mediation as a child diversion option, but it is not specifically stated in ours. Ours focuses more on restorative justice practices. Yes.
But we do this. Is that something? What you think? Could we put that in section 16?
Because section 16 has options, Minister, it would necessarily hurt because it doesn't have to be taken up, but it's an option if it is appropriate.
Okay.
Because section 16 speaks to child diversion program options.
So, I mean, when you look at 16(1)(n), with the consent of the victim to provide specified services to the victim at such time, place, and in such manner as specified, that could include mediation.
Well, it is broad enough to
Yes.
possibly consider that as an option.
So, go ahead.
It would make sense to include it specifically as an option. So I don't know if you want to add it to be said in N, but it would make a lot of sense. In terms of while child diversion is going on as well, mediation, it acts as a method to end the matter and take it out of court. It actually empowers the victim in terms of a remedy.
And would resolve a lot of...
And it would resolve. And given your new legislation,
right.
I think it
would
work.
Look at that recommendation and see how we could put mediation, that is relationship between the victim and the offender, in appropriate cases, okay?
Yes, I was questioning why the mediation generally is used for civil matters. The matters that come to child diversion are criminal matters which are already done with using restorative justice. So I'm not certain.
No, you have a very good point there.
Okay.
Yes.
So one of the arsenals in the court is you do have court mediation in the criminal realm. So even though you have restorative justice, as I said, the mediation can take place on spot with the court staff, and it does empower the victim, and the victim may seek compensation right there before the court. It is helpful, and it as I said, it may allow the victim to take a particular course in saying, well, I will allow the child diversion because there is some consent from the victim, especially if the victim is an adult. So it's actually different.
So what
there is mediation in criminal proceedings between the parties, which kind of sends it away from the jurisdiction of the court if it is successful, just like restorative justice, but they are somewhat different.
Right. What happens, Member Buchanan state, restorative justice is a normal thing where there's an offense. But sometimes the victim wants more than just restoring the relationship. They want maybe medical bills be paid, a compensation, apology, everything. So what we would want to do there, Ms. Eaton, is to say inclusive of restorative justice and mediation where appropriate, okay? Somewhere in section 16. All right? Continue. We go to the Jamaica Psychological Society. You finished?
Continuing with the Ministry of Justice and Constitutional Affairs, consider including a general provision as O to intake any child diversion options not explicitly listed. Such other diversion programs that may be prescribed from time to time.
Right, that is a residual all-embracing clause, which could be O. Okay, Ms. Eaton, good.
The Jamaica Psychological Society recommendation that section 16(1) of the Act explicitly require A, a structured family assessment, and B, the inclusion of evidence-based family intervention as part of the diversion process. Embedding family-focused components within the legislative framework will better address the root causes of offending behavior and enhance the likelihood of sustainable rehabilitation outcomes.
Well, it is there. It is in the Act. If you look, we adopt it. I mean, it's in practice. So we support that recommendation.
Minister,
sure.
A question. Structured family assessment, inclusion of evidence-based family interventions. How does that work in practice? Because that now requires the adults to basically submit themselves to the program. How does that work?
No, Senator Shereen Golden Campbell. What we'll ask them to, but if you look at 16E, to spend a specified number of hours with the child's family members at such place for such time or for such activities as may be specified. So in practice, to the best of my knowledge, Ms. Clark, isn't that followed? That the child, in the program, the child does interact with the family. Has to. Isn't that? Go ahead, Ms. Clark.
That's not what I'm understanding this to be asking us to do, though. What I'm understanding this to ask us to do is different from what is set out at paragraph E. Evidence-based family interventions. What does that mean? It would seem to me that there's some sort of formal assessment of the family and some sort of prescription affecting the family, involving the family. That's different from just directing the child in the program to spend time with the family. And while I support the idea behind this, how would that work in practice?
So in practice, a child...
You have any suggestion? Go ahead.
So in practice, once the child comes to the program, the initial intake, risk and needs assessment, does an assessment of the family intervention as well. If we identify that there's greater need for more interaction, a part of our mental health services, family counseling is provided. Outside of that, we also work with the CPFSA for their parental skills training that we allow where appropriate for parents to be a part of it, yes.
So it's now being done. Okay. Go ahead.
Please don't lose the point, because I see what the senator is saying. Is this a case where if you make an assessment and there is some lapse in terms of parenting, is it that there is some mandatory mechanism for the parent to participate because it's evidence-based, and what would be the requirements to satisfy if we're reading this recommendation and adopting it? So how do you get parents? Because a parent might say, I mean, I have nothing to do with this picnic, him uncontrollable, make the court deal with him. How do you deal with that?
If I may, Minister, I'm also in agreement with what was stated, because here it says structured family assessment and inclusion of evidence-based family intervention. What does that really mean? And I think that would have to be broken down somewhat to explicitly explain what does that family intervention what would that look like? And so is it where case managers are actually going into the home and making a proper assessment, or a psychologist? What does that mean? So I think we need to really look at this to see if it's something that's already been done in the Act, or do we need to expound more on what should be done?
Well, if you look at even the rationale from the Psychological Society, when they spoke, I think you, Ms. Clark, you had agreed that is being done. Go ahead, Ms. Clark. Go ahead.
So what it says, if you go back to section 15 and look under minimum standards, under J, as a minimum standards, promote the involvement of parents and guardians as appropriate. So that is what it says generally, as a minimum standard, to take into account any actions or interventions for the child that would involve a parent or guardian. So it says promote the involvement of parents and guardians as appropriate, as a minimum standard.
And Ms. Clark, is that being done?
It is being done, but I just want to remind us that in the best interest of the child, we cannot detain them in the program because a parent is unwilling to be a part of the program. So when we find instances like those, we now have to modify the program and remember that in the best interest of the child and considering time and them just wanting to be done with the program, we now have to forego that, because some parents can be very difficult, and while there's nothing in law to hold them, we cannot detain them either.
Yeah.
And Minister, if I may,
Sure.
I definitely appreciate what was just said, but I also recognize the sentiment expressed by the Jamaica Psychological Society as being a fundamental one. We end up with children requiring diversion, not because they were born problematic, but oftentimes, and maybe all the time, because of inappropriate parenting, insufficient parenting, etc. So if we have a child diversion program that is attacking the issue of the child, or the issues that the child is having, when we meet upon these situations, and I'd love to hear from the team, how often are you seeing a situation where parents are hands off? And what then becomes the next action for the program? Does the program refer those parents? Is there somewhere in the state system that the problem of the parenting is referred so that it can be dealt with, maybe not within the program, but elsewhere?
Okay, Mr. Wright, you wanted to say something?
I just wanted to indicate that based on what Member Golding is saying, my mind is taking me to CPFSA and the fact that if a child is in a situation where parenting, there are parental issues, the child then becomes one that is in need of care and protection and would fall outside of diversion in that regard. So it then would be thrown on my friend over there.
I would say, Ms. Clark, could you just indicate that in all the cases, the parents are part of the program? Go ahead, Anna.
I cannot say in all cases, but in most cases, the parents are a part of the program. If we identify that there's an issue, as just mentioned, we work collaboratively with CPFSA to ensure that the parenting component through the parental skills training or other services that they provide is treated with, if all of it cannot be done. Because we do family sessions, but it wouldn't be as comprehensive as the program provided by CPFSA.
Good. Yes.
The Minister, how do we?
Hold a second.
Where's it?
Hold a second, Senator. Go ahead.
Senator, go ahead.
No, you go ahead.
No, Minister. I was going to make reference to clarity, where it makes reference to something else. So that's why I want Senator to go ahead first. Then I can speak to this.
My question was, so that collaborative working, that partnership, is there a formal referral to CPFSA of those parents? And when in the process, whatever the intervention is from CPFSA, how does child diversion then know that this referral was acted on and deliverables met in the interest of the child who was a part of the program?
All right. Yes.
Where's the accountability in that?
My concern is that I do think that we have to stick strictly to child diversion, because child diversion by itself cannot answer all the questions and reach out for every need that there is.
And that is where...
if we don't do that, we're going to fall into problems. So I do believe, and we go all over the place, sometimes you have too much and you achieve nothing because you can't. And I really
to be fair though, the matter, CPSA, FSA, do take on this matter. Go ahead and explain.
We do have officers as part of the Child Diversion Committee who are specifically there to identify issues as it relates to parenting or any matters of care and protection. So that already exists.
Okay, Ms. Clark.
I was going to clarify that there is actually formal referrals that are made to CPFSA, and we monitor the cases, similar to the same thing that we do for any other referral to any other entity. And so our intake assessment, the form that we use, we ask them about, is the child living independently of a responsible adult, information about the support that is provided by the parents, and if we identify this as a risk factor, then the intervention is provided accordingly.
What I can say to sum up is that from all the indications, I thought all, but you said the vast majority of cases, parents are part of the child diversion program. And many of the successes that we report on child diversion, it's coming from the parents who thank us for recovering the child. So if you look at my sectoral presentation, I think we put a few success statements there, where it is the parents who are speaking, thanking the child diversion program for assisting them to recover their child. And I think we had a couple of cases here where I think it was a middle-class lady who would thank us because this child was lost. And after the child diversion program, she came and thanked. And I have seen this many times where it is the parents who really are thanking us rather than the child. Okay, so we don't need to, no changes, okay? Go ahead, no.
The health
Sorry,
AIDS
Minister.
Healthcare Foundation of
Sorry,
Jamaica.
Minister.
Yes.
There's one clarity I wanted to seek. I note that Section 16.1 speaks to one of the requirements is for the child to spend time with a specified number of hours with the child's family members. 16.1e, the child offender to spend time with which child's family members? Is that the victim child or which family member?
It's the child who is on child diversion.
No, look at what it says. It says a child is required to spend time, number of times the child's family member, the child victim, the child offender to spend time with his own family member.
Yes.
What the hell is-
No, the truth of the matter, no. What happens is that oftentimes, to the best of my understanding, the child may well not be living with the family.
That would then mean that the child may be in need of care and protection for whatever reasons. It kind of seems odd that if you find a child who falls within the diversion mechanism, and then you're saying you want the child to spend time with his or her own family members, but you would have to ascertain why was this child not with the family in the first place, and could it be a child who's in need of care and protection, and you might need greater intervention for that to come about. It's how it's written, it needs further clarity.
You want to help us?
Because I'm looking at it, and if you want a child to spend time with his or her own family members, you would have to see why wasn't this child not with the family in the first place to have found him or herself possibly committed an offense. Does this child need some intervention?
Go ahead.
Just for clear interpretation, the legislation is saying, subject to the provisions of this act, a child diversion program may direct or require a child to do one or more of the following things. One of the things it's saying that for the diversion program, there's a mandatory amount of hours that the child is to participate in family activities. We don't live in a bubble, you know. We have parents who work at night, the father works at night and the mother works in the day. Son comes home, never sees the dad. This is a requirement on the legislation to say that there must be some family cohesion. There are parents who don't sit at dinner tables with their children. There are persons who don't sit in the TV room with their children for 18 years. So this is a part of the corrective measures, and I don't see any need to change the wording of this act because it's clear on its face.
I go further.
Minister, please.
I go further.
Minister?
Yeah, go ahead.
Yeah, I don't think this provision is presuming that the families are, the child doesn't live with the family. I don't think that presumption can be made. And I agree with Member Buchanan that my interpretation of this Section E is that it is specifying some element of family time. I don't think it is presuming that they are separated or not living together.
I think it can be interpreted.
I get the impression it's some structured family time that may be prescribed by the program directors. That, for example, you need to spend some time at Hope Gardens with your child between the hours to take out the child, or some element of recreation or something to that effect. I don't think it is saying they are not living together, and we can presume that. I think it is. I agree with MP Buchanan, Member Buchanan, in terms of
Minister Williams, next time you're speaking, to put on your camera. But I don't know if.
Oh, I'm sorry.
Yeah,
I don't know. Sorry. My apologies, Minister.
No problem.
Chair.
But may I just say, I don't think there's any unique position. You have situations in which it might be a mother who works as a helper and is working elsewhere, a living helper, and maybe just see the child on the weekend. So the question is, what more can be done to say that that child can see the mother who might be working overseas? You get me? So the question is, how best can that be approached? And I see nothing wrong with it being there, that the child may not be interacting with his family members as much as they should, and to what extent that could be done so that they interact more, okay? And my understanding is that the child diversion program now does ensure that the family members interact with the child, right? Yes, Senator Golden Campbell.
If I am understanding the intervention from the CPFSA, I'm reading that intervention to be concerned about possible danger to the child if it is that the child was separated from the parents living elsewhere, that an assessment would need to be done before you mandate that they spend a certain number of hours with the child. But I'm also understanding the team at Child Diversion Office to be saying that that level of assessment does happen, and that before the prescription of a program is designed, they would have ascertained that matter through the family assessment, etc. And if a referral for care and protection needed to be made, it would be made to the CPFSA. CPFSA, am I getting your concerns, though you didn't say clear? Am I getting your concerns right?
Yes, indeed.
Ms. Clark, what's your response?
I'm just confirming that, yes, and it is an option that is provided. And while we cannot make the referral for care and protection, that stands with the court, but once we identify a risk, from doing the intake assessment, we make the necessary referrals, or we provide the necessary plans for the child and the family to be able to. So if we identify that a child may be experiencing physical or sexual abuse, we are reporting that matter as well. So it is something that is ongoing, yes.
Okay, thank you. Continue.
We're now on, yes, part 2, the comment from page 24, the comment from the AIDS Healthcare Foundation of Jamaica. It is recommended that section 14 and 16, the Act must explicitly state that diversion programs should include educational and counseling interventions addressing behavioral and developmental risk affecting adolescents. However, clarifying the scope of these interventions would reinforce the rehabilitative focus of the diversion program while supporting the development of life skills and positive behavior decision-making among participating children.
Yes, yes, dear. I don't think we need to comment. I mean, that has been done, huh? Right. So we can move on. Section 17 now.
Section 17.
Who's dealing with that?
So section 17 of the Act speaks to the selection of diversion options. So it reads, in selecting or recommending a diversion option for inclusion in a child diversion program, the Child Diversion Office and the Child Diversion Committee, respectively, shall A, have regard to the matters set out in subsections 2 and 3, and B, consider the nature of the offense and the public interest. Subsection 2, where a child diversion program utilizes the diversion options under section I and L or 2, before determining the object to be supplied, the Child Diversion Committee shall A, obtain the written consent of the child's parent or guardian, and B, be satisfied of the financial ability of the parent or guardian to supply a specified object or to make a payment on behalf of a child.
Okay, go ahead with the recommendations.
There are 2 recommendations for this section. One from the Ministry of Justice and Constitutional Affairs. Consider including section C, have regard to the best interest of the child. Reference could be made to factors noted in section 2.2 of the Act.
Right, I mean, you know, this is always the case. But you want it in the Act? Are we saying we should have it in the Act? We must always have regards to the best interest of the child. Because it's always an overreaching position.
It's in the Act, Minister.
It's in the Act.
The best interest of the child, but the recommendation was for it to be specifically restated here.
Good.
But it is generally in
In
the
the
Act.
Act. But why would you want it to be stated here again? Is that that's our recommendation? I mean, always it's in the best interest of the child. But you're saying it would make sense to put it here in Section 17? Is that so, Mrs. Cole-Jarrett?
Recommendation, Minister, to make sure that it is captured as we had recommended it on the matrix.
If you're saying we should, you want it as 17.2c.
But Minister, it is already in the Act.
Well, that's
I mean,
the
from a
point.
legislative drafting perspective, I don't see that it needs to be
That's what
put
I'm
in Section
thinking.
17. It's a governing principle of the Act.
It's an overriding position. But why do you want it specifically here?
May we come back to this one, Minister? I'm not sure that the matrix has the fulsome recommendation that we would have
Right,
written.
because
So we
it
can come
seemed
back.
to me we would be saying what is obvious. 17.
May I please your Minister, Chairman, Mr. Chair.
Go ahead. Go ahead, Minister
Yes.
Williams.
But correct me if I'm wrong, but Section 17(1)A states shall have regard to the matter set out in subsections 2 and 3. Doesn't subsection 2 speak to the benefit, the best interest of the child?
No, it doesn't, Minister Williams, but what we're saying is that it is the overriding feature of the Child Diversion Act itself. You're always acting in the best interest of the child. So to put it at different sections of the Act, to my mind, is superfluous. Because it is an overriding position.
Yeah, that's what I'm saying. My apologies. When I said Section 2, I meant to say that Section 2 above,
I know, but
at the beginning of the Act speaks to the best interest of the child already, which is what we're actually saying.
Right. So, but the ministers asked first to recommit it when they say why.
Oh, very
it
well,
should be
very
there.
well, very
All
well.
right. So continue, Ms. Graham.
Jamaicans for Justice recommend that we repeal and replace Section 17. The new section should read, for the purposes of this Act, there are 2 levels of diversion intervention. I'm on page 25 of Part 2. A, Level 1 diversion, which applies to a child alleged to have committed an offense listed in Schedule 1, and B, Level 2 diversion, which applies to a child alleged to have committed an offense listed in Schedule 2, and Level 3 diversion, which applies to a child alleged to have committed an offense listed in Schedule 3 or an offense referred by sole discretion of the court. Level 1 diversion measures may include A, an oral or written apology to the victim, B, formal caution and release, C, symbolic restitution, D, community service, E, compulsory school attendance, F, victim offender mediation, or G, a family group conference. And for Level 2 diversion measures, they're suggesting that it may include Level 1 measures, and in addition, a structured therapeutic, vocational, educational, or rehabilitative programming, and B, supervised community integration with reporting conditions, or C, intensive mentoring by an authorized service provider. And Level 3 diversion measures may include Level 1 and 2, and in addition, a residential or non-residential therapeutic order under Section 14 of the Child Care and Protection Amendment Act of 2023. The assignment of a child to a diversion level shall be made following assessment of the child by an authorized officer having regard to A, the nature and seriousness of the alleged conduct, B, the child's assessed risk and developmental needs, and C, the best interest of the child.
All right, so you go again with the best interest of the child. Ms. Wright, you said you had a rationale why we should have the best.
Just to assist the ministry, the rationale for 17.1 and adding the best interest, the ministry had said that this provision does not make reference to the best interest of the child. Any provision in the Act concerning diversion options or decisions regarding the child should explicitly regard the best interest principle as a foundational concept in promoting the overall welfare of the child, notwithstanding any general best interest provisions in the Act, which would be Section 2.3. So the recommendation was to include a subsection C, to have regard to the best interest of the child, and reference could be made to the factors noted in Section 2.2.
May I just say, what is being recommended by Jamaicans of Justice and the ministry could be consolidated in a C, where you look at an appropriate measures that would be imposed on the child and which would be in the child's best interest. In other words, what Jamaicans of Justice is looking level 1, level 2, level 3. You know, the truth of the matter is that they see that you're going to go to court. The likelihood is that most of the cases won't go to court, because what is being proposed there is that the court could impose a community service order, an apology, and that sort of thing. That may happen, but we're looking at the majority of cases which we hope will be dealt with outside the court process. And therefore, I think, Ms. Eaton, one of the things we should be looking at to consolidate what Jamaicans for Justice and the ministry is proposing, an appropriate measures that could accord with the offense or the behavior of the child, and make such provisions to remedy or to rehabilitate the child, bear in mind the offense committed, and which could be in the best interest of the child, which is what both the ministry and Jamaicans for Justice are proposing. But I wouldn't want to repeal Section 17 and put in level 1, level 2, level 3. You would consolidate it and put an appropriate measure to assist the child in getting back to good behavior, and such measures should be done with the best interest of the child in mind. Okay? Go ahead, Ms. Eaton.
Thank you, Chair. Morning. So for my benefit, Section 17 is relating to specific diversion options, right? So 17 is speaking to how you proceed if one of the options that is being considered for the program, and of course each program is tailored to the specific case of the particular child. So 17 relates to the options that are set out in 16. So 16.1L, where it speaks about restitution of a specified object to a specified victim. If the object is capable of being replaced or restored, or if the object is not capable of being replaced, make a symbolic act of restitution to a specified person at such time, place, and in such manner as specified in the child diversion program. Now this option, the selection of this option, is subject to subsection 2 of 16, where it says, which speaks of the circumstances where there is no identifiable person to whom restitution may be made. The child may be required to make amends for the benefit of a community or community association or organization, a charitable organization, a welfare organization, or any other appropriate institution by directing the child to provide a service, or B, the child's parent or guardian to make a payment on behalf of the child to the organization or institution specified to receive the payment under the child diversion program.
Right.
So that's the context for 17.
So bear in mind, as Ms. Eden has pointed out, and those of us who have been involved with this, it might be a one incident. It's not that the child is of abnormal behavior, but the child may in fact have damaged a car, throw a stone in a car window. So the child is being charged with malicious destruction of property. Now the question is the parent capable of replacing the vehicle? The penalty. But at the same time, an assessment should be done as to whether or not this is a child who will do it again, or is in the business of throwing stones at car, or damage, or engage in any sort of malicious destruction. And that is why I see, what is being proposed as 17.2c is an all-embracing clause. You see, that could say an appropriate measure to respond to the offense, and for such other appropriate program that would be in the best interest of the child. You understand? Because the child may have caused a physical injury to the victim. The victim may want compensation. But the question arises, here's a child who has committed a physical offense, an offense, damage to a person or property. And the question is, you don't just want to say the child, you just accept an apology. It may well be that you have some appropriate measure that to show the child, if you do it again, you have to go through this sort of rehabilitation. Go ahead, Ms. Eden.
Thank you, Chair. So in relation to the ministry's proposal, as I understand it, the concern is 17.1b, which is in selecting or recommending a diversion option for inclusion in a program, the office and the committee shall B, consider the nature of the offense and the public interest. So the concern by the Ministry of Justice is that there should be express reference there to the best interest of the child.
Right. So when you look at the nature of the offense and also the public interest, you want in 2C, 17.2c, provision for a program of measures to respond to the offense, but not so much as punishment, but what would sort of let the child reflect on what he or she has done in order to say you don't do it again.
Chairman, if you read 17b, you would see why it is absolutely necessary to include the best interest of the child principle following the consider the nature of the offense and the public interest, because you're asking a judge certainly to consider the public interest, which has to be in that consideration, balancing that the best interest of the child is paramount. And so it may be necessary to include it here. I could see why the recommendation
That's why C
is
comes
there
in.
now. Right.
So you want to see that encompasses all of these ideas.
It's not just the idea; it's the principle to be balanced with what is the consideration here, which is to consider the nature of the offense and the public interest. So while considering the nature of the offense and the public interest, one must not forget that the best interest of the child is to be considered in the round.
No, I'm agreeing with you, Member Buchanan, because in a normal criminal process, the judge basically said, you've done it, you plead guilty, 3 years, or 3 years suspension. But that's not what you want.
No, you want the best
you
interest
want
of the child.
something to say, would a suspended sentence be in the best interest of the child? And like Louis Dan says, no. So you want to say that the child must do some restorative justice program, apologize to the victim, whatever. So you don't necessarily just want a penalty that in the normal course of criminal process you do. You want some appropriate program that is in the best interest of the child. So, Ms. Eden, you're going to just add a likely 17.2c that reflect the discussion, all right?
Excuse me, Chair.
Yeah, go ahead.
No, it would be 17.
C.
1B.
No. Remember 17.2c.
No, 17.1c. It would be C. That follows B.
Okay, what?
Right.
I thought it would be put in 2C.
Mr. Chairman,
Yes.
if I may,
Yeah.
and this I think is a question for Ms. Eaton. The object of the act includes taking into consideration the best interests of the child at section 3. And so my question to Ms. Eaton is, in specifically including that language in select sections, what are we saying about the sections that do not include that language? If we have the governing object of the act being to take into consideration the best interests of the child, is it not sufficient for that to govern all the sections of the act? One, and two, if we say we're going to include it in specific sections, what does that do to the sections that don't include it specifically?
Go ahead, Ms. Eaton.
It raises the possibility of uncertainty and inconsistent interpretation.
That's a concern.
That's a very serious concern,
Right.
Mr. Chairman.
But
and why I raised it, because at the end of the day, some court may have to interpret these sections, and I am cautioning against including it in the specific sections, because we have already said that the object of the act is to take into consideration the best interests of the child. I am cautioning against it from
I agree with you, Senator Shireen Golden Campbell. Save and except it depends on how Ms. Eden drafts it. It could say consistent with the provision of this act that it should be in the best interest of the child. All right, yes. Go ahead.
But Chairman, wouldn't you have had to say that up front from the beginning that, the act is in the best interest of the child, and then you can say inconsistent with?
Well,
I mean, I'm not a lawyer, but I'm just thinking as a layperson, if it's stated up front, and then we say consistent with, I think that would be a better proposal. Instead, because if we put it in one place, I think we need to keep it in every section, to say it, to repeat it over and over again.
You wanted to say something? Go ahead.
Just in particular, and this is specifically for Ms. Eaton, the trouble is how B is worded, consider the nature of the offense and the public interest. The very aspect of it is that a judge may very well say there's no diversion if we're looking at the public interest and the nature of the offense, and the best interest of the child may be pushed to the side. When you're balancing anything, the best interest of the child in relation to the child diversion legislation is paramount. It is the highest. Nothing should trump or cause a child to lose the possibility of diversion, if at all, and the type of program that the child may be able to get. So I take the point, but it's a matter for Ms. Eaton to say whether or not, when looking at B, consider the nature of the offense and the public interest, if you would put language to be balanced with the best interest of the child. If not, it may cause, in practice, the child to lose a benefit. And if you practice in the court, you'll understand that sometimes judges find it very painful too when a prosecutor gets up and say, if the child is in a gang, the conduct of the boys in relation to this sexual offense, I don't think they should even get. And if we look at the public interest, if we curb behavior, child diversion,
all right.
In practice, Mr. Chairman, we can't just leave this out. It's isolated, and I do take the point of the senator, save and except for in the absence of B being corrected, it would be absolutely mandatory to include it. there.
No, 1 second, 1 second. 1 second. Just if you look at section 14(1)(b), it says, based on the evaluations of the Child Diversion Committee in the particular case of the child having regard to one. So from upfront, the best interest of the child is considered. All right, so, sorry, go ahead.
Right, if I may, Minister, the Act actually sets the context for references to best interest. If you look at subsection 2.2, hence why 17 would have referred back to 2.2, it says where there is reference in the Act to the best interests of the child, it tells you what the factors are that are to be considered. So wherever in the provisions the Act reference best interests of the child, these are the things that you look at. And similarly with public interest, in separate provisions, it also specifically mentions in the interest of the public.
So you see, the Act on several sections keep speaking about the best interest of the child. So, you know.
Which is why, Mr. Chairman, this part, so where 17.1 is concerned, its inclusion is important. For that party, it's there in 14 and it doesn't affect the rest of the Act. So,
but it's also in 2.2.
And it's also in 2.2, but in for this part, when you're asking, a judge may very well say, well, it didn't tell me to consider the best interest of the child in this section.
But 2.2 is overriding. So it's 14.
So you did say where it's referenced. So you're saying no, reference it here in this section, and we should be okay. Okay, well, I'm okay with that. Once it's already stated that where it's referenced, and we're going to reference it here, then I have no difficulty with that.
There's no danger, but
I don't think there's a danger.
It's not a danger. That's what I'm saying. But Mr. Chairman, here where the danger is, the Chief Justice will very well say, when you're in the court, you made the law, so what you're advocating for, and so say you had it or you didn't have it, and why, right?
So that's why I said, in response to Senator Goldenkamp, and say to Ms. Eaton, consistent with the best interest of the child. In other words, because it is there already. Okay. All right, we have to move on. Go ahead. So we are now at section 18?
Yes, Minister. Section 18 on page 36 of part 1. Non-implementation or discontinuation of the child diversion program.
Right.
Reading section 18 of the Act, which speaks to non-implementation or discontinuation of a child diversion program. 18.1, a child diversion committee shall not implement or shall immediately discontinue any child diversion program in whole or in part that is harmful, exploitive, or dangerous, or is likely to harm, exploit, or endanger a child's physical or mental health. B, is not appropriate to the age and maturity of the child. C, is likely to disrupt a child's educational performance. D, is structured in a manner which may exclude the participation of any child admitted into the program. E, fails to take into account the harm or loss sustained by the victim. Or F, the court or the child diversion office objects to being implemented or continuing.
All right, stop there. So what is the recommendation?
The recommendation from the Ministry of Justice and Constitutional Affairs in regards to section 18.1, rather than wording the provision in a reactive manner, consideration should be given to revising the provision to specify a more proactive approach to the effect that the program should not be harmful, exploitive, inappropriate for the age of the child. This proposed rewording places the emphasis on the highest standard of attention to the development of the program from the initial stages. It may also be necessary to review the functions of the Child Diversion's Office and the Child Diversion Committee for further clarity. It is noted in section 5D that the Child Diversion Office is given autonomy to develop, approve, administer, and supervise child diversion programs, which could bring into question matters of accountability and actual role of the Child Diversion Committee in the process. Consider removing the word exploit from section 18(1)A, being that the word exploitative is also used.
Right, colleagues, I think what the ministry is saying, the way the section is framed is very negative. And the ministry wants it to be more positive. It will do programs that ensures that the child physical and mental health is taken into consideration. Plus, so Ms. Eaton, I don't have a difficulty. Colleagues, in other words, what is being suggested is that we make it much more positive to say it should do this, rather than, which is what most of it has been saying. But section 18 is one of the few negative sections saying what should not be done. And it could be more positive. So, Ms. Eden, you will find a way to make this section a bit more positive, bearing in mind the recommendation. Okay? If there are no other concern, we move to section 19.
All right, so section 19 speaks to failure to comply with or to complete a child diversion program. So 19.1 reads, where a child fails to comply with or to complete a child diversion program, the Child Diversion Committee shall, within 5 days of receiving notice of the non-compliance or non-completion, advise the constable or court that referred the child, as the case may be, of the child's failure to comply with or complete the program. 19.2, upon being notified by the Child Diversion Committee of the failure of the child to comply with or to complete a child diversion program under subsection 1A, the referring constable may charge the child with the applicable diversion offense forming the basis of the referral. B, the court may, for the child to appear before the court, 1, issue a warrant for the arrest of the child, or 2, cause a summons to be issued in respect of the child. Subsection 3, when a child appears before the court under subsection 2, the court shall A, inquire into the reasons for the child's failure to comply with or to complete the child diversion program, and B, make a determination whether the failure is attributable to the child.
We don't need to go into further read. What's the recommendations?
Recommendation from the Ministry of National Security and Peace. For section 19, subsection 2, the ministry submits that if the constable decides not to proceed with the charge, then their role within the process is complete and the child would be released.
I'm not too sure I totally agree with that. Anyway, we'll come back to that. Let's hear what the Ministry of Justice recommends.
The Ministry of Justice, the following in relation to section 11, subsection 3, section 12, and section 19. Consider revising the reference section to consolidate overlapping provisions. Section 19.1, to indicate who provides the notice, who the notice is received from, to the Child Diversion Committee, and the form of the notice. Section 5, function of the Child Diversion Office, and Section 7, function of the Child Diversion Committee, could benefit from a revision to further clarify and demarcate functions. Consider revising relevant sections to clarify the distinction between non-compliance with and failure to complete to assist administrators of the program and the courts to understand the specific circumstances of each term in order to better align the associated implications. Recommendation. It is being recommended that section 19.1, that where a child fails to comply with or to complete a child diversion program, the Child Diversion Committee shall, within 5 days of receiving notice of non-compliance or non-completion, advise the constable or the court that the referred child, as the case may be, has failed to comply with or complete the program. As it regards to section 19, subsection 2, consideration to be given to clarifying what should obtain in the event that the constable or, for instance, decide not to charge the child, as the child having failed the program, may still be at risk for delinquent behavior. It is being proposed to review Section 19, subsection 5C for intent and clarity. It is recommended that Section 19, subsection 6 should also perhaps refer to Section 19, subsection 5C.
Right. Well, first of all, I don't think the fact that the constable decides not to charge should not be a reason why the child shouldn't go on a diversion program, because as the Ministry of Justice team has said, the child may still be involved in delinquent behavior. So what I think has been proposed, Ms. Eaton, is a clarity in Section 19 to make it clear that if a child has shown a misconduct, that child pattern of behavior may well suggest that the child could benefit from a child diversion program, even though the constable decides not to charge. So it should be clarified, because the child may well benefit, having been referred to the constable, and when investigated, there's a pattern of behavior which may, and that one incident the child may not be charged, that the child could still benefit from the child diversion program and therefore could be put on the program. Yeah. One second. Go ahead.
Just for clarity, Minister, this section refers to failure to comply or complete the program. So the child would have already gone through the program, but at that point, the constable would be required to decide whether or not the child is charged. But if the constable decides not to charge the child would have failed diversion program, what next?
Go ahead.
That's what I was addressing, Chairman, because a constable may have, we have gone through this a million times, that there may have been several reasons why a child would have failed the program. Usually if a constable, and I'm giving them the benefit of the doubt, decides, you know what, son, daughter, your parents hopeless, I'm not going to put you through this anymore, go home. Mm-hmm. A lot of times the failure would have been not on the child's part, and maybe the recommendations would have come back, because what I will say is that generally if they fail the program, the constable actually charges and takes it up to the court and passes it to the court. So we have to be careful how we do that, because if the constable makes a decision not to continue, that is an informed decision from where he sits, and it may be the end of the matter at that time. And that's in the context, Chairman, that the child would have participated in the diversion process, but something would have caused its failure.
Right. How, Ms. Clark, would you determine a matter like this, that the child having been referred to the child diversion program by the constable, they have not successfully completed the program? So you can't go back to the constable and say, everything is good. We can say that the child. How would you deal with a matter like this? Or how has it been dealt with?
It has been dealt with in keeping with the legislation in terms of we report to the police by way of a return to indicate that the child was not compliant. They now may proceed with charges, because depending on the case and depending on what the victim wants, then to indicate, okay, I consented to the child going to child diversion and they didn't complete it, that implies that they may need something else, and as such, the discretion is with the police to now make the determination.
But if they were put on the program, if the child was put on the program, and say the child doesn't turn up at all, then it's a matter for the police, you're saying?
So if the child doesn't turn up at all before we return the matter, we usually give them 6 months, Minister, to get compliant. So before we return the matter, we would touch base with the police to indicate that this case that you sent to us, we have not been able to contact the child. We're asking you to do a home visit or to get in touch with the parents. We try to exhaust all the options before.
No, but within a month you should be able to say to the constable, the child has not been coming.
No, we do say, it's not that we don't indicate to them within a month. I'm just saying, the period that they get to become compliant is that.
It's 6 months.
Yes. So within that period, we're in contact with the police and the court as well, just to try to find out, you know, what is happening, what can be done, if they need additional referrals and so on. But by the end of the 6 months period, that is when the police now will have to decide what they're going to do.
Go ahead.
Six months, that's half a year. I think that is way too long.
No, to make a determination.
What is the reason why? What is the reason why they're given that much time, the 6 months period? What determined that?
So outside of the other considerations, so for us, a program doesn't really commence until the individualized diversion program has been signed. That in and of itself can take 2 months because the intake assessment, I'm just giving you so the intake assessment can be 2 hours, 3 hours because we're doing a very, you know, thorough. After that, and we craft the treatment plan, it now has to go to the committee. And once the committee approves the plans, we contact the child and parent to say, this is what is going to happen, and we call them in for them to sign the individualized diversion program. When we call them in, we don't know what stage they are yet. So a child might be in the middle of exams, for example. A child might be out of the country, depending on what is happening. So we cannot just return the matter because the time has passed. We have to give them that grace period to now say, okay, I have signed on to the program and I'm willing to do it. However, these are the things that are happening in my life. And again, in the best interest of the child, we cannot just return. But overall, we do communicate with the police during the period to update them on what is happening.
All right. No,
Minister, I have a question, Minister,
sure.
through you, Mr. Chair. So am I to understand, Ms. Clark, that the compliance can be done within 6 months? So, for example, if it is that the treatment strategy is prepared and the individual, the subject complies, let's say for argument's sake, it can be done within 3 or 4 months if all is in place. But the 6 months is a cap. Is that what you're saying? Hello?
Go ahead.
So a program can be done within 6 months. And it is not a cap necessarily for the ones who are in the program because we don't stipulate a time frame because all the programs are individualized depending on the need of the child. However, the 6 months is for usually for children who are not compliant, for them to get compliant and be, you know, compliant. A part of the program.
Okay.
But if we do have a child that is considered low risk, for example, they can be in and out of the program within 4 to 6 months. Yes.
Thanks.
Okay. Thank you very much.
So, in relation to Section 19, we would ask that we adopt and ask Ms. Eaton to look at it in terms of clarifying what Ministry of Justice is asking for it to be clarified. Now, Ms. Sada, you had a question in relation to Section 18. Would you like to just say the concern?
No, Chair, I noticed that there were 2 other recommendations higher up for Section 18, and no recommendation of the committee was given for that. So I was just pointing that out. I know that you're going to amend, the recommendation was to amend the Section 18 itself to give a proactive approach. So I guess that would cover the other suggestion about removing the word exploit.
Right. In other words,
but there's also another part about the child diversion office, the functions. I'm not sure if you'll touch on it in the other recommendations or if you wanted to address it now.
this is what is on Section 37.
On 18, Minister, so the recommendations from the ministry. But we can take it that the matter of revising the Child Diversion Committee and the Child Diversion Office in terms of the functions would have already been dealt with before by the committee in the discussions to say we need to clarify the roles. So this was just a reiteration of that because it came up in
Ms. Masado. And obviously in the positive approach to Section 18, we would exclude exploitive. All right, we would just say these will be done, or should ensure to be done, which would ensure that the question of exploitation is not even considered. All right, so and in relation to 19, we just would ask that the section could be clarified as requested by the ministry, and therefore that's the recommendation, we adopt it. So section 20 now.
20 of the Child Diversion Act speaks to minister to prescribe standards, approve counselors. So the section 21, the minister may prescribe standards, guidelines, procedures, and timeframes for the development, implementation, and supervision of child diversion programs. B, the form and manner of implementation of child diversion programs. And C, requirements, procedures, and formats for record keeping and reports. Subsection 22, for the purposes of this act, the minister may approve in writing suitably qualified counselors and psychologists in respect of each parish. And B, shall cause the names of the approved counselors and approved psychologists to be published in the Gazette.
Aren't we doing that now, Ms. Clark? I'm not too sure we Gazette. Because not many persons want their name to be gazetted anyway. But generally, we are doing most of 20, except the gazetting. Should we really include that thing shall cause the names of approved counselors and approved psychologists to be gazetted? I'm not too sure that people want their names to be gazetted. Yes. And I think we should. And in fact, it is even mandatory. We have a number of psychologists on the program, but to the best of my knowledge, I don't know if they would want their name to be gazetted.
I agree, Chairman. Was there, I recall something about a particular type of psychologist. I'm just wondering if forensic, was it? Yeah, but there was a lot of chatter about forensic psychologists, as in there was a particular type, and that the wording was to be changed. I don't know if the definition, right, so if the definition changes, is it just any psychologist, or is it the forensic psychologist now, in light of that? Asking, I know we went through a lot with it.
Mr. Chairman?
Yes, go ahead.
Can I ask what was the rationale for including that 2A and B? Is it that these are the psychologists that the diversion office will refer or utilize in the diversion program? Is that it?
Ms. Clark, can you answer that?
So the child diversion program currently has mental health service providers that include psychologists, social workers, and counselors. For the psychologists, though, we would not just move to get only forensic psychologists, because they are usually more suited for correctional facilities to understand why the behavior has led to that, while we can benefit. We need counseling psychologists to be able to provide the interventions and the psychotherapy that is needed, as well as the clinical psychologists to be able to do the screening and diagnostic testing and stuff. But at the same time, we don't want to limit it to just forensic psychologists, and we are in the process now of trying to even get psychiatrists on board for the medical interventions that are required.
And so, is there a list that the ministry uses? How do I, as a psychologist, begin to make myself available to the office? How am I chosen versus psychologist Brown?
Go ahead.
So every psychologist that touches base with the child diversion office or contacts us, we have a list of things that are required. So the criteria, we have a checklist that they have to meet certain criteria. Once that is done, we indicate to them that we are now going to move to get the approval to engage. The first aspect of that approval is that a background check has to be done as well, and we have to see that they're certified in terms of...
About how many psychologists do you have in the program now?
Currently about 40.
40? Mm-hmm.
And psychologists are registered under the Supplementary Medicine Act, right? Can't remember the exact name of it. Profession Supplementary to Medicine. Are they not?
Council.
Supplementary to medicine.
So we have about 40 psychologists now in the program.
So it's a mixture, Minister, of
Yes,
psychologists, social workers, and counselors.
So if they're registered under the Act, what is the purpose of a background check on a psychologist? I'm not understanding that.
So in the best interest of our children, everyone that comes into the program, we do a background check. We cover the cost for it, but it is prudent to do it, just in case.
What does that background check entail? I'm sorry, Minister, if you would
go ahead,
give me
go ahead. Go ahead.
So before we proceed to do a background check, they have to consent to it. The background check entails, we normally engage for the mental health service providers, we engage a private member of society that does that for us. It includes a visit to their community, getting information from NIB as well as a sex offender registry, a whole list of things, and what the report includes if they find any adverse traces or anything of that sort.
Bearing in mind we're dealing with children, so it's very important.
Yes. I have several concerns. One is, if psychologists are registered under the Profession Supplementary to Medicine Act, I want to bet, I haven't looked at the Act in a very long time, but I want to bet that convictions for sexual offenses, things like that, would preclude them from registration, would it not? I'm concerned about a couple of things in relation to this. One is, yes, I appreciate that it's children, but if these professionals are registered, they're registered. If they have a valid registration under the Act, they're registered. I'm not understanding why we commit resources to a private investigator to go to find out whether or not they have convictions, because I would imagine those things would need to be disclosed. And if, say a criminal record check was needed, then they have to provide a police report. I don't, we're talking about a program that has not, not resources ad nauseum. I'm not understanding why we would do this with professionals registered under an act that governs their work.
No. All right, Ms. Coljar.
Do we do that with doctors? Do we do that with the psychiatrists as well, registered under the Medicine Act?
Go ahead, Ms. Coljar.
Maybe this will add a little more clarity to the discussion. So if the committee may recall, we had gotten comments from the Jamaica Psychological Society. So on the definition sections, we had approved counselor and approved psychologist. Their recommendation was the designation approved counselor lacks sufficient clarity or specificity of qualifications. So they suggested that we change it to professional counselor that falls within the scope of practice of licensed counselors and professionals registered under CPSM. So that would actually take care of the registration component and the component of identifying these counselors and psychologists as compliant with the Act as approved.
And I certainly support that recommendation.
Right, because our definitions say approved counselor and approved psychologist, but the recommendation is that that be changed to professional counselor and professional psychologist.
No, if you look, if you look at the recommendations...
and that once they're registered, what then would be the purpose of the minister's approval? I don't see why the minister's approval would be needed. Once they are registered, licensed under Jamaican law, that is de facto the evidence of their suitability and fit for purpose.
Well, if you look at the recommendations now from the Jamaican Psychological Society, if we accept that, then the section can be redrafted, so you don't need the minister's approval if you're taking the professional counselors and professional psychologists.
Minister, there's one other concern I had with it, in terms of the approval aspect of it. Ordinarily, when the state interacts with private sector in any kind of partnership, sometimes, or most of the times, these things are subject to our procurement rules. So some of the activities, of course, some of the services, of course, are exempt from normal tender process. So it struck me that the minister would be approving qualified counselors. And we're now saying that we're going to accept the, registration under the relevant act. And that should be it. I mean, there should be a roster where people can apply to be considered as part of the support for the program once they're registered and licensed under Jamaican law. But how it's then determined which psychologist will treat which child is going to depend on the particular circumstances of the child and the specific skill sets that psychologist brings, that the specialization perhaps that the psychologist or psychiatrist has. And so is not likely to be a part of the requirement for tender for services, and shouldn't require the minister's approval, because it just lends itself to, if you like Dr. John Brown, then Dr. John Brown is going to get all the work under the child diversion program, and Jane Smith may not get any.
Well, at the moment, to the best of my knowledge, have we, in our investigation, Ms. Clark, have we had situations where we don't accept a psychologist?
We have had situations where they might finish their schooling, but they're not licensed yet. And also want to remind us that we have members from the Jamaica Association of Social Workers. So we do have clinical social workers as well on the team that provide intervention also. But so it's social workers, we have the counselors. So under the registration, you can be registered as a counselor or a psychologist, and there are also guidance counselors who are at the master's level that we interface with. But in terms of not utilizing them, maybe they have not met the requirements. Remember that we stipulated that we have the checklist that we have to go through. So for that, or we've not had any though that I'm aware of that a background check came back adversely and we had to say no.
What concerns me, if the matter is working well, why change it? Go ahead.
Minister, I'm also in agreement.
The fact that inherently unfair.
So I hear Senator Goldie. I hear what you're saying. However, it's not just psychologists that we're talking about who are already have a board that they have to be compliant. You're talking about social workers. You're talking about counselors as well, and you're also there's another
mentors. And we check, for instance, we train mentors.
And you're talking about guidance counselors.
Yes.
So I think it's important to just leave it as is, and because it's not just psychologists who are registered with a board.
You see, Senator Sharon Golden, the likelihood is that if the person is a professional psychologist, very little, if any, background is done. But let me tell you, we now train mentors to assist in the program. And we have to be extremely careful because the mentors are the ones who engage these youngsters. And you don't know which of these personnel could abuse the child. And therefore, the background check is absolutely important. So it is not so much the professional psychologists we're thinking of or the professional counselors, but you do have, as you say, guidance counselors, mentors, persons dealing with these children, that the last thing we would want is we put the child to interact with a mentor and the mentor turned out to be a pedophile. So all that
Minister,
background
let
check
me
has
ask
been
the
dealt with.
question this way so that you can understand my concern about the practice of how we do this. And I'm not at all suggesting that we should do anything to lower the standard of the safety of the children. Under the definition section, approved counselor means a counselor approved by the minister under 22. Approved psychologist means a psychologist approved by the minister under 22. That is the genesis of the problem, because the minister has no business approving counselors and psychologists who are licensed and registered under Jamaican law. That's the standard, just like a doctor, just like a lawyer, just like an accountant. So if we review the definition and subject the definition to the relevant legal registration under Jamaican law, then we don't have to go into this thing about background checks. Now, the background check matter concerns me because of cost and resources. And I think it's doing work that is already being done. So my question to the team would be, what is the expenditure that you engage in terms of doing background checks? That's one. And two, when it comes to guidance counselors, social workers, is there a similar licensing system in Jamaica for guidance counselors and social workers? Can I just get up and call myself a social worker, or is there a regulatory body that I am subjected to? Because that would change things for me in terms of the need of what you're doing, because it just seems to be a waste of resources.
Go ahead. Go ahead. Thanks, Senator.
Chairman, thank you. I'm going to address firstly the background check. The background check. The best interest of the child requires it. There are professions, respectfully, who after they let you into the profession, you're not required to bring a police certificate every single year. Not only that, the fingerprint office does not always go hand in hand with convictions. Background checks for the purpose of child diversion is about adverse findings. Yes. There are persons who have come in conflict with the law that has not been brought before the court because other things would have happened.
Absolutely.
Mediation and everything. So if we are protecting the child, Minister, respectfully, you sit in the chair right now. It is the approval by you, because if anything should happen, I will be the first to say, how could the minister make this happen? Head should roll. I will be the first to say, resign, 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 because if you put a psychologist, a guidance counselor, a lawyer, a fireman, an Indian chief under your watch, respectfully, it's the best interest of the child, and that's what we are here for.
No, I must tell you, yes,
I want to endorse fully what my colleague has just said. And if you are instituting any program at all, if the ministry leads and the minister is at the head, what is the mischief we're trying to correct to say he should not?
All right, Ms. Coulter.
Yes, just to add clarity to the minister's approval. So outside of the fact that you would have approved psychologists under the body, the minister is approving those persons for use in the child diversion program. So I think that's the point of the provision.
Let me,
not to approve them as psychologists or counselors, but for use in the child diversion program. Us having done our background checks and otherwise satisfying the minister that, yes, this person is licensed, yes, we have not seen where this person has any offense, etc. So the minister, by that, would then say,
all right,
okay.
Let me just say this, Senator Shereen Golden Campbell. Some of the most outstanding professions have attracted persons who turn out to be not acting in their profession's best interest. And that is why, out of an abundance of caution, I know that, Ms. Clark, when we discuss child diversion, anyone that we put on the program, we want to make sure that they are above board. So in particular, I'm not saying that we do extensive and repeat checks of, professional psychologists and professional counselors, but especially in regard to anyone working with these children, we insist that there should be protection because you don't want to put a child who is vulnerable because you're saying to this child,
Mr.
this is the
Chairman,
person who is going to
Mr.
do it.
Chairman,
Yes. No,
I have
but
to follow the logic. I have to follow the logic and the principle of what you are setting out to do. And while I appreciate my colleagues' concern about the best interest of the child and safety of children, which I fully support, I have to follow the logic. When you are approving counselors and psychologists, which I maintain the minister has no business approving, when you are doing that, you are approving them for use in the program. Can the team please indicate to me how many times the background check is done? Is it only done on approval of the use? So if I sit in the program for 10 years, do you check me again? Because if you don't, this process doesn't make sense to me. If only time you check me to see if I am safe for children is when I'm being put on the list. And you don't check me in 5 years' time. You don't have any monitoring capacity to check me. Then what are we doing?
Ms. Clark, you want to answer that?
Just with greatest respect, you have moved the goalpost because you're talking about having checked. We are talking about when you are recommended at first. We have a duty to check and see what is happening. What I can't understand is, in anything that you institute, you have a body that guides and governs it. Are you saying because I am qualified as a doctor and I have practiced for years, you have applied to me, I don't have the right to check what is there before?
No,
I
beg understand. You. Hear what I'm saying. Hear what I'm saying. I'm going to repeat. Hear what I'm saying. These professions, and I don't have clarity now on, I'm assuming a guidance counselor is also a teacher. I don't know about social workers. I stand to be informed as to whether or not there is a regulatory body that deals with social workers. And I ask the question, can I just get up and call myself a social worker? My position is this. If there are regulatory bodies, whether it is the Psychiatric Association, sorry, and that they're not regulatory, the Medical Association, or whatever body deals with psychologists, if those bodies exist and these people are required under law in order to practice in the jurisdiction of Jamaica, to become licensed and registered under the relevant act, what further check do we need to be doing other than asking them to present to us their up-to-date registration certificate? That's my first point that I made. The point was then countered by saying that we have to check because of the best interest of the child and concerns for the child. I agree with the need to assure ourselves of the best interest of the child. However, I believe that is satisfied by the registration certificate we get from these bodies who are empowered under law to ensure that the people they're admitting to practice in Jamaica are people of good character, etc., and are properly trained and have met the qualifications for training. If it is that you want to be satisfied that they are safe people for children, separate and apart from their registration under law, governed by another body, then it must be something that you're telling me you're satisfying yourself of periodically. Because to satisfy yourself when they are approved does not hold for the entire time that they participate in the program.
Well,
if you're saying that you have to check at the beginning, you must be checking periodically.
Well,
because being good in 2022 don't mean that I haven't committed some offense that would disturb you in 2025.
No, and Ms. Senator Sharon Golden Campbell, I think you're right. There must be regular checks. Okay, Ms. Clark? But sitting here as minister, I want to do the same thing. Because I want to make sure who you put on the program to work with children are above board. With due respect, there are many professions who cater to professionals who I'm not too sure they're in the best position to deal with children. And you have one or two rogues in many professions who get into these professions and they are not necessarily, capable of dealing with children. Some of them are abusive. They're not necessarily treating the children in the manner which is in the best interest of the child. So speaking for myself, and I hope the committee will support me, I think we should continue the program because at the end of the day, it is the ministry. If anything should go wrong with any of these children, the ministry will be in disrepute. So that at the very minimum, we can say we did the investigation, nothing turned up, right? Right, so we can move on.
I'm saying
So no,
that
Minister,
you
we
have
can't
been
move on. We can't move on because your intervention a while ago is to continue the monitoring. So what is the amendment that we are proposing then for continued background checks and monitoring? Can I get the question answered as to the cost that we are spending on background checks?
Can I say something? Sometimes it is not, hold on, you have a doctor, a lot of us think of a doctor. There are some very bright and excellent doctors, but they have no bedside personality. And some personalities, if you're not well, can deal with that. Another person cannot. When you're thinking of children in a child diversion program that has psychological problems or different problems, you can also be looking not just at the professional qualification, but whether or not that person has some element of humanity, for want of a better word, sympathy, understands. You look at a person, you say, so-and-so is good, but two so-and-so, let's use so-and-so because they understand, they're from a particular background, and that goes for social workers as well. That's why you have people who are social workers who understand and can deal with certain problems, and some people who have never been exposed to it just can't understand why children behave in a particular way.
All I can say, to the best of my knowledge, Ms. Clark, is these check-in costly?
Costly is subjective, Minister.
So from the last time I checked for a local background check, it was 35,000. For an out of town, as in out of Kingston area, it would be $45,000. But I just wanted to quickly clarify in terms of the mental health service providers, when they're assigned, so they're assigned to the parishes. So the child diversion committees have a say in terms of what is happening, because when the treatment plans are presented to them, they know the number of mental health service providers they have, the specializations that they will have, and so on, and cases are assigned at the local level. So at the head office, outside of the vetting and the request for approval and so on, and contract, the engagement of the service providers would be at the local level.
Right. So I would say, colleagues, dealing with children, we cannot be enough in terms of being careful. And that would be my position. So we continue. I would say, what I think Senator Golden Campbell is asking, though, I suspect for each case, if it's a new person, we do regular check-in.
So for a case for a new mental health service provider coming on, it's mandatory that we do a background check, similar to just coming to work at the Ministry of Justice.
Exactly.
If you're an attorney, you still have to get the background check done, and that's a part of our initial process.
And your child diversion officers, you do the background check for them too?
Yes, we do. But we do take the recommendation in terms of periodically conducting
recheck. I think that's a good point.
We do take that.
Okay, thanks.
And so that is going to now be put into the Act?
The recommendation is a recommendation, Ms. Clark. I would say what Senator Sharon Golden is asking is whether the regular check-in will be done. I am not too sure yet. Go ahead, Ms. Eaton.
Thank you, Chair. So I just wanted to remind the committee members that there is a regulation-making power, and that some aspects of the policy may be more appropriately addressed there. The other thing I wanted to pose a question is, for clarity, the recommendation of the committee, once the in relation to 22B.
22D.
If memory serves, there was some discussion also about the mandatory gazetting requirement, separate from the discussion that is currently taking place.
I'm not too sure that particular, Ms. Eaton, Ms. Clark, I don't think we should change it rather than to say to be gazetted, put that the approved counselors and approved psychologists should be, I don't know how you'd put it, that you do a regular assessment, a reassessment over annually or biannually, as the case may be. All right? So we're not going to gazette it. So that
Why
part,
not, Minister?
Yes. So
why not? Why are we not gazetting it?
I'm not too sure.
Why would we take it out?
I'm not too sure that these persons necessarily would want their names to be gazetted. We have not been doing it, and I'm not too sure it is necessary. Okay.
But if you're establishing a roster of safe individuals who are going to administer services in the child diversion program, why would we not gazette it for transparency purposes? Why would I not, as a citizen, be able to know who are the psychologists that are likely to be assigned in a program?
I would say a lot of psychologists and guidance counselors may not want their names to be gazetted when they want to work on the program.
And but their names are gazetted as a function of the act that they are registered under.
No, because...
So why not gazette it here?
To be fair, we have not been doing it, and I'm not too sure it is required. Sorry?
But it is required, sir. We have it in the act. It is required.
I said I'm suggesting that we should remove it. I'm suggesting we should remove it.
On the basis of what, Minister? What's the rationale
because
for
it's not necessary.
Why is it not necessary, Minister? You're giving me conclusions. You're not giving me reasons, and I'm trying to understand.
Because the committees do an assessment, and once the committee has done an assessment of these persons, and they are periodically used, I don't see why the need to have it gazetted.
Well, I can tell you why I think it should be gazetted, and that is that I have a right as a citizen to know who are the professionals treating with the children of my country. I have a right, if there are people who we have to be concerned about, who are subjected to background checks and vetted, I should know who they are.
What are the views of the members? You don't agree with the gazetting, Mr. Buchanan? What's your...
Chairman, I don't take issue with it. Nobody reads the Gazette, so if you gazette it, it don't matter.
All right. Go ahead, Ms.
And for the purposes of public notice, it could be addressed otherwise. We post things on our website, so we could have a listing of the psychologists and counselors that we use on our website.
So,
right, and then too, because sometimes they turn around, maybe gazetting is not the best option, because each time a counselor or professional changes, then we have to go back to the gazetting process.
Should we also, what we would do is to put it on our website, the ministry's website, and in that section, Ms. Eden, we would just put that the approval of the persons working with the children will be regularly assessed and names disclosed.
We have a formulation that we use all the time, Minister.
Sorry?
The formulation that we often use is basically to say that the minister shall publish a register of approved providers or whatever.
No, right.
Ms. Eaton, no.
What I'm referring to. Bear that in mind, okay? So instead of section B, we put it in that frame and we regularly assess, okay? Thanks. That's section 20. Let's move on.
There was one other recommendation from the Ministry of National Security and Peace. Consideration should be given to the introduction of mandatory case management for all children referred to the diversion program.
I don't understand that. What does that mean? Huh?
Have that.
Sorry?
We have it.
It's done.
It's done.
It's already done. Okay. All right. Section 21. I think Jamaicans for Justice has a recommendation, and 21. Yes, it's on the second part. Huh? Go ahead.
So Section 21 of the Act speaks to constable may issue warnings or police caution. First schedule. So Section 21(1) reads, subject to subsection 2, where a constable has received a notice of or reasonably suspects the commission by a child of a diversion offense specified in the first schedule, the constable may, in accordance with provisions of sections 22, 23, and 25, issue an informal warning, a formal warning, or a police caution as appropriate in the circumstances to that child. 21(1)(a), having regard to the facts and circumstances of the case, the requirements for referral of a child to the child diversion program for admission into a child diversion program. 21(2), a constable shall not issue a formal warning or a police caution without the written consent of the victim of the diversion offense unless the constable is unable to ascertain an individual or other person as the victim of the diversion offense for the purpose of giving consent due to the nature of the diversion offense or the facts of the case.
No problem. What's the recommendations?
Jamaicans for Justice, it is being proposed to insert a section 21A entitled Diversion by Prosecutors. It should read as follows. Subject to Section 9 of this Act, notwithstanding any charge laid, the Director of Public Prosecution or an authorized prosecutor may decide to refer a matter for diversion if satisfied that the child acknowledges responsibility for the alleged offense, the child in the presence of his or her parent or legal guardian or an appropriate adult, and after having the chance to receive legal advice, consents to diversion, and C, the offense is eligible under Schedules 1 or 2. 4, upon deciding to divert, the prosecutor shall, A, notify the court registry or clerk of court in writing or electronically as prescribed within 48 hours or as soon as practicable that proceedings are deferred or any charge is withdrawn, withheld, pending completion of the diversion program.
I think we have discussed this, In other words, remember, Ms. Eaton, I don't know how much you would want to take this into what we said, that referrals could come directly from the DPP or the clerk of court, so that Ms. Clark, remember we had said, at the moment it's from the court or from a police constable. But when it gets to the clerk or the DPP, we're saying that the clerk, rather than taking it to court for the court to make the recommendation, in appropriate cases, the DPP or the clerk of court could make the recommendation to diversion, and therefore some of what Jamaicans for Justice have proposed could be taken into consideration. Is that okay, Ms. Eaton?
Chair, yes. So in terms of the drafting proposal, as had been previously indicated, that the provisions are highly interconnected, so how that would find expression may not be necessarily this way if this is indeed taken on by the committee. The other thing, too, I had wanted to mention earlier is that in looking at the provisions that treat with matters concerning referral or where the child fails to comply with or complete a program, it is useful to consider how those situations would operate in the context of a referral by a prosecutor.
Well, remember now, the prosecutor, a charge would have been laid, okay? So the question is, once the child completes the program appropriately, just like the constable, then the charge would be dropped. But if the child doesn't complete the program appropriately, the prosecutor would be informed that the matter has not been, the child has not completed properly, and the prosecutor may well then take it to court for a matter to be tried, okay? So just like in the case of the constable who makes a decision whether to charge. And remember now, we were saying that that is how it should have operated in the court. But the court, some judges have taken the view that you plead guilty. Our position is that before it goes to court, the prosecutor, and remember the DPP said that would be the best approach to avoid the child going to court. All right? So we'll accept that recommendation. 22, so no, you have an...
The Jamaica Constabulary Force, the following are being recommended for Section 21. We recommend that Section 21, subsection 1B, be amended to incorporate the requirements set out in Section 9, which outlines the conditions for referring a child to the program. Page 28, Minister, of Part 2.
28?
Of Part 2.
Oh, good, fine.
We recommend that Section 21, subsection 2, be clarified to expressly state that the written consent of the victim, whether given in relation to a police formal warning or a caution, must meet the same standard prescribed in Section 9, namely that consent must be free and informed.
Colleagues, have you seen that? The Jamaica Constabulary Force, separate and apart. That's 21. But isn't that natural? I mean, what's your position on that, Ms. Clark, that recommendation? You see it? The recommendation of the, we do that, is that no done? I mean, the consent has to be free. Go ahead.
If a referral is being received from the police, there's a referral form that is attached, and part of that, the victim has to indicate their consent on the form as well.
So that is now being done?
Yes, it is.
Okay, so we approve, it's being done. All right, 22, section 22.
So moving on to Section 22 of the Act. Section 22 of the Act speaks the informal warning by constable. Section 22(1) reads, where a child accepts responsibility for a diversion offense specified in the first schedule, and in the opinion of a constable, the diversion offense committed does not warrant a formal warning or a police caution under the Act, the constable may give an informal warning to the child, A, warning the child that the child is suspected to have committed a diversion offense specified in the first schedule and has accepted responsibility for the diversion offense. B, advise the child of the penalty to which he may be liable if convicted of the diversion offense specified in the first schedule. And C, warning the child to desist from engaging in acts or conduct constituting the elements of a diversion offense. Subsection 22(2), an informal warning by a constable shall be an oral warning. Subsection 3, a constable who issues an informal warning under subsection 1 shall A, notify the parent or guardian of the child, B, the child diversion office, C, the relevant child diversion committee. Subsection 4, the notification of an informal warning by a constable under subsection 3 shall be made in writing in the prescribed form and include A, the date on which the informal warning was issued, B, the identity of the child to whom it was issued and the parent or guardian of that child, and C, the circumstances that warranted the issue of the informal warning to the child. And finally, subsection 5, no record is required to be made or kept of the informal warning or any copy of a notification under subsection 3 by the constable or otherwise at the police station.
All right, go ahead and the recommendations.
We're on page 43 of part 1. Recommendation by the Ministry of National Security and Peace for section 22, subsection 4, include an age verification process in the Act. It is a view of the Ministry of National Security and Peace that the police exercise due diligence in the conduct of their investigative process, which includes the garnering of the necessary identity details of the child, person in order, or the person in order to properly charge the individual with the crime. Further, the ministry submits that the administrative processes that govern police investigations and the laying of charges are matters that should not be disturbed by this legislation.
We have no problem. We're just setting out the obvious. We're not going to really interfere with their investigations. All right, so what does the Ministry of...
Recommendation by the Ministry of Justice and Constitutional Affairs for section 22, subsection 1B, consider amending the provision to include specified in the first schedule for which he or she is being warned. In section 22, subsection 1C, consider amending the provision to include constituting the elements of the diversion offense for which the child is being warned. And in section 22, subsection 3, include clear objectives and expectations regarding the notification process and whether the Child Diversion Office or the Child Diversion Committee is to act upon receiving the notification.
Mm-hmm. All right, that seems... Continue.
It is to be explicit and clear in the Act when a constable may refer a child for participation in a child diversion program in light of the conflicting provisions of Section 9, subsection 1, Section 22, subsection 1, Section 22, subsection 3, Section 23, subsection 1, Section 25, and subsection and Section 26.
Ms. Eden, could we please sort of remove what seemed to be conflicting? Okay. All right. So we accept and support what is there.
In Section 22, subsection 4, consideration to be given to include age verification processes in the Act.
Not a problem. Okay. So all of that we agree with. Jamaicans for Justice?
No, the children's advocate.
Where's that?
On page 32 of part 2. The children advocate consider inserting within section 22, subsection 5, that though no record of an informal warning issued by the police is required to be kept at the police station, a record may be kept if the police so determines.
I don't have a problem with that, but is that necessary to put in the Act itself? I mean, the police would normally keep it. There's no doubt. You see, the police, it's a matter for the police, whether they want to keep a record. So I don't really think it's necessary to put that in the Act. Okay, go ahead, Ms. Coco.
Well, I think because it says that no record is required to be kept. So it's not a requirement, but if they so desire, they may
keep
one.
Put it another way. From the police, put it in their big book. The likelihood is that it is in their electronic. No, by the way, quite a few police stations still have that big book. They haven't got used to doing it electronically. But you see, the truth of the matter is that the police usually maintain their records. They rarely delete. Once it's there, it's there. So, you know, and the section now provides as a may, it's not shall. So we leave it as is, okay? And so in relation to section 22, we just see if the ambiguity as pointed out by... They may. So it's a matter for them, and I don't really think we need to put that in the Act itself.
And the JCF has a recommendation on this that would address the... Yes. So the Jamaica Constabulary Force, in relation to section 22, 23, and 25, in reference to police discretion for warnings, cautions versus charges, we recommend that the Act expressly requires the police to consider factors including the seriousness and nature of the offense, the alleged offense, the sufficiency and reliability of the evidence available to support prosecution, and C, the overarching principle of the best interest of the child. Recommendation in relation to Section 22, subsection 5, consideration must be given to amending the Act to require that a record of such warnings be maintained.
Well, they are supporting the children's advocate, and actually it's not saying me.
Yes.
I think it may be a good idea to just put it this 5 seating to say these informal warnings should be maintained. Okay.
That's the extent of recommendation for
22.
Section 22.
Right. So we go to Section
Could you
23
repeat?
now.
Chairman, I'm sorry. Could you just repeat you just last said? Are you saying the informal warnings on the subsection, there must be a record kept of them?
The record should be kept. Not, in other words, once an informal warning has been made, the children advocate had indicated it and the police said that it should. So I don't have any difficulty. It's maintaining their records. Yes.
So if I may, Chairman, I'm taking issue with that. Because of the nature that most of where child diversion is concerned and the conduct is juvenile conduct, the keeping of records would actually be starting a profile for minors who the objective of the child diversion is to not have them having any adverse findings at all. So I'm thinking that if you are going to allow them to keep records, that would actually go adverse to the act. Especially a warning is not a crime. A warning is not an indication of if the discretion is a warning. Otherwise, put them through the diversion, because if you're giving a warning, you shouldn't be able to be keeping records. So I'm strongly opposing this.
Ms. Wright?
A counter argument actually could be made, member, that keeping the records of the informal warnings would actually be for the best interests of the child in terms of tracking children. Based on the numbers that may come in with our constable dealing with, children coming in for very minor offenses, if there is no record as to them being warned, the official record being warned, they may be coming back into the station for another minor offense by another constable. And if there isn't anything there that says, wait, Tommy Jones came 3 weeks ago, Tommy Jones is coming back to us, that then would trigger for the police to make it be not an informal warning, but a formal warning. And then it would continue on the track, maybe not the formal warning, but a caution. So I think one of the bases upon which the recommendation was made for the tracking is so that they can keep track of children who have this propensity, it appears, to be committing minor offenses, being warned informally, and different constables may not know that one constable had already warned Tommy. Tommy is coming back again. So I think perhaps that's one of the rationales that could be used to have informal warnings, just simply a record being kept. Also, I think for data purposes, because I know that there is provision in the Act for, correct me if I'm wrong, informal warnings, they are to be sent to the Child Diversion Office and the committee. And I don't know if there is perhaps some concern that where there isn't a formal book or, a record keeping the tracking the warnings, that the true number of children that are being quote unquote diverted because informal warnings is a form of diversion. So there may be a concern that the numbers that are being sent to the Child Diversion Office, and that would feed into the amount of children that are being assisted through diversion is not being properly reported and recorded.
Right. So I would say, Member Buchanan, the probative value outweighs the prejudicial value.
Mr. Chairman, I'm not going to delay, but if you read the Act, it sets out clearly what the constable is supposed to do, pass the information, say it to the parent or the guardian of the Child Diversion Office, who is the right place for that tracking and keeping of the records. I'm simply saying that for the JCF to be creating profiles of children is very problematic.
But with due respect,
that's what it is. That's what a record keeping is. And I can tell you, I say this
Remember,
100
no,
times.
one second.
Mr. Chairman.
This doesn't go on your police record, you know?
No, Mr. Chairman.
Yes.
Mr. Chairman, we've gone through the advent of violence contributors. We have trouble in this country treating children like children. And I'm simply saying the spirit of child diversion is that if a child finds himself being parochial larceny to mangoes, it has nothing to do if he throws a stone for destruction of property. And the diversion aspect of it, the keeping where informal warning is concerned, it is creating a profile, and I'm saying respectfully that that is dangerous and should not be allowed. That's just my position, respectfully.
Senator Sharon Golden Campbell.
Minister, I have a question, a couple of questions. My first question is, what exactly is informal warning versus formal warning? What is the purpose of an informal warning in the context of the child diversion program?
Can you help us, Ms. Clark?
And I'd like to have some follow-up after. Thank you.
An informal warning is usually an oral warning to indicate a police might see a child behaving in a particular way or hanging out at a particular spot. It's just an oral way of saying, I notice that your behavior is one that can lead to this. Please be careful and desist from doing certain things. The formal warning it appears to be a little bit more serious. It is not at the stage, though, where the child can be charged with an offense, but the child is taken to the police station, and their parents are notified about what is happening, what they're seeing, and the risk factors of this child now coming into conflict with the law.
So if I were to say then that the informal warning is the kind of warning that a police constable or other officer gives in the normal course of policing, would that be accurate?
Yes, it would be.
Right. So basically,
no, Minister, please. Minister, give me a
ahead.
moment, please. So I'm trying to go through a little, and I know you're speeding up today, but it's important to understand why we are importing into legislation things that really are a part of the practice of officers. So an informal warning under section 20, sorry, where am I? 22? Yes, and under section 22 requires, we have here put into the law that we're telling the constable what they must do in issuing an informal warning. We're telling the constable that they must notify a parent or guardian, the office, the child diversion office and the committee, and that they must put into writing the fact of that notification with some prescription as to what the notification must contain. And I'm asking the question now, what is informal about that? Because by virtue of the fact that we are legislating actions that police constables and other officers of the force take in the ordinary course of their police duties, when police see youngsters on the street and they engage with them, they may have verbal conversations with them. Well, it can only be verbal. They may have conversations with them. They may, in the course of that conversation, warn them about their conduct. By placing it in legislation, by prescribing how officers do that, there's nothing informal about this. It becomes a prescriptive, legislated act that a constable has to observe certain things, and the subsection 5 provision saying that no record is required to be made. A record is indeed made. A record is made of the notification, and the notification sets out the specific circumstances that the child was warned about. What is informal about that? And why is it that we are putting this in And then we have in section 23 a formal warning. What is the purpose of what you are calling informal warning, which I am humbly submitting to the committee is not informal?
No, well, you know, I must admit, colleagues, on reflection, the informal warning is a matter for the police. We can't stop them. But I agree with I now agree with you, Senator Sharon Golden Campbell and Mr. Buchanan. I don't think we should put it in the legislation. In other words, if the constable issue a formal warning, and we are saying yes, but in case of the informal warning, I have no doubt the police will record it. But it's not. We shouldn't make it a point of legislative action that you must do it. The likelihood is the police are doing it anyway. So I am not too sure it is necessary for us to put it in the legislation. Let them do as a part of their administration, a part of the community policing, a part of their checking on the children in the area. So we're not going to accept the recommendation, okay? The formal warning is there. The informal warning, where you just talk to the child, if they want to put it in there, if it is serious, they put it in their logbook or register it. So I agree, I am now on reflection saying, leave the formal warning definitely to be put and notified to the child diversion officer. But why are you doing it? You're not going to inform the child diversion officer of the informal warning. Then there's no need for us to get involved with that. Okay? Right, there's no need for us to get involved with it. You understand, Ms. Wright? I mean, it's a policing arrangement, so we're not going to accept the recommendation.
Minister, beyond just not accepting the recommendation, are you then saying, which is my proposal, that the entire section 22 be removed from the Act?
Section 22?
Sorry, yes, sir. Section 22,
yes.
The section dealing with informal warning.
So I want to I want to understand this. Are children sent to child diversion with formal and informal warning? Both? No, none. So, yes.
No, both.
No. Can you answer?
22. Yes.
So diversion consists of two different aspects. You have currently we have informal warning, formal warning, and the caution. Those things can be done by the police. In respect to all three, there is no obligation on the police to refer the child to the child diversion program, which is the other aspect of diversion. So the child can be warned, cautioned, that's it. Or the child can be formally warned. Well, the child can also be referred to the child diversion program, which will then trigger the options, the plans, all of the work that the child diversion office does. So there are two distinct things, but they fall under the big umbrella of diversion. You're diverting children from going into the formal court system.
So, go ahead.
Chairman, not to be antagonistic, but I'm not of the view that the informal warning should be removed from the Act. It is only the recording aspect of it. As we legislate, there must be a guide, and constables must be able to look into the legislation to see what their duties are. They have the power to informally, which is oral engagement, which to me is the one I promote. It actually strengthens community policing, and it brings back the aspect of the relationship between police and children, citizens at large. So I was only taking issue with the the aspect of turning it into recording. And generally, police officers create great relationships in many parts of Jamaica with young men who, just by a warning, they are now members of the JCF. So We can't ignore that.
If you don't mind, Senator Sharon Golden, we won't remove section 22 or 21, but we won't add that it should be recorded. Okay? Thanks.
Minister,
Yes.
I also don't want to be antagonistic, but I'm having difficulty with how we are proceeding to write law. Section 22, governing an informal warning, is a discretionary provision. The constable does not have to give an informal warning. So that's the first thing. However, if the constable chooses to give an informal warning, we have set out in this act how the constable must give it. And we have also insisted, contrary to what the officer said just now, yes, there is no referral to the child diversion program, but if there is no referral to the child diversion program, then what is the purpose of subsection 3, which is a mandatory provision? Once the officer gives an informal warning, he shall notify the parent or guardian, the child diversion office, and the relevant child diversion committee. If the child has not been referred to a child diversion program, what is the purpose of those notifications to the child diversion office and the child diversion committee? Law has to make sense. It has to be consistent with supporting a policy position that can be enforced and serves a public purpose. This provision, section 22, with the greatest of respect to all of my colleagues, is nonsensical. It's nonsensical because it is the practice of the police to give oral warnings all the time. They speak to the youth all the time. If they are to choose to do so, we are now telling them, this is how you must do it. And when you do it, go notify the child diversion committee, go notify the child diversion office for a child who's not yet in child diversion. Come on. This don't make sense.
Mm-hmm. If you would permit me, I am constrained and compelled to respond. Goodly Senator, I'm going to say to you that in this scenario, if an officer exercises a discretion to informally warn a child who otherwise could have been placed in child diversion, that has to be put somewhere. If that child goes on to do something extremely horrible, somebody's going to say, but why wasn't the child diversion committee aware of it? There is a duty to tell the parents, which is something we would want to happen, that the child has come into conflict with the law, and this is my discretion that I exercise to give him a verbal warning or her a verbal warning. The parents have to be notified, as well as the committee, and I still see much value in this because it's not adults you're dealing with. It is a child who has been given good grace from a constable, and there must be a communication to the relevant authorities why it is that they weren't put into the program. So this is absolutely necessary. It's informal, and it could be checks and balances for a constable who says, I can't bother deal with this child diversion, I can't bother charge, but the child is in conflict with the law. And that's the purpose of the legislation, and this particular section will be necessary to ensure that there are checks and balances when we are dealing with children in conflict with the law.
You see, there's no doubt that... Go ahead.
Minister, can I just respond?
Mm-hmm.
Because here's the problem I'm having, and I understand what my colleague's sentiment is about. What is the child diversion office and committee empowered to do? And when is the jurisdiction of the child diversion office and committee engaged? It is not with respect engaged at the point of an informal warning. If the child has not been referred, the child diversion committee and the office of the child diversion has no jurisdiction to be taking any information about that child. Contrary to this act, if they do so, this very act that 22 is written into.
You
If
know,
they are to receive information about a child who a police officer has given an oral warning, an informal warning, what is the jurisdiction to do that? They have no jurisdiction under this very act.
You know, Senator Sharon Golden Campbell, this section reflects what I have been asking for and why I don't mind it remaining. Section 22 is dealing with incidents that are not criminal offense. In other words, what the constable sees is a misbehavior of the child that could eventually lead into a criminal charge. So the idea, if the child had committed an offense, then, you know, it's child diversion. But this particular section is indicating to the child and to the parents and to the child diversion committee, we see a behavior of a child that is delinquent, and if it is a matter that the child diversion committee, or it's recommended to the child diversion committee, this is one in which, in my view, that the child diversion committee should inform CPFSA. This is where CPFSA comes in, because once that occurs, it may well not, it's not a charge which normally you would send to the child diversion committee, but this section 22 is dealing with that gray area that I've been talking about all the time, that comes between CPFSA and child diversion. So the informal, this, to my mind, and you may be right, Senator Sharon Golden Campbell, this is one in which the constable, rather than referring it to the child diversion committee, should be sending it to CPFSA. CPFSA, what do you think? Let me hear your views on this. One second. Yeah.
I'm in agreement, and it ties into the early warning system that we're currently looking at, where things are referred to us in that regard, so that if it's picked up early, we can provide intervention to prevent the child going on to commit other offenses and may need some behavioral treatment.
So you know, Senator Sharon Golden Campbell, I think you've picked up the point we're making, that it seems to be a bit out of place in the Child Diversion Act. But it is it's appropriate to the extent that it allows the Child Diversion Office to say, here's a case that they can refer to CPFSA. This is one in which the police really should be referring it to CPFSA rather than to the Child Diversion Committee. But for the moment,
Minister, that's precisely the point.
Yes.
That is
Minister, may I?
No, one second. Go ahead, Donovan, and then Ms. Wright. Go ahead, Donovan.
Yeah, the goodly senator's position resonates with me strongly. I am in support of her proposition. I don't see why we need an if it is informal, and it does not trigger the child diversion committee. And you see, we have a problem here now in terms of profiling. MP Buchanan is averse to profiling. But the very act of notifying the child diversion office of an informal warning and the relevant child diversion committee is, in my view, some kind of profiling, not necessarily from the police perspective, but it is building a record or a profile of a child. And even the formal warning, if I'm to understand correctly, does not. It relates to matters that are not that arise to. Does not warrant criminal proceedings. So there's this distinction between formal and informal. I am tending to agree with Senator. I don't think that is necessary in the legislation, this informal warning. The police does their work, informally warn. I've seen it happen on the streets all the time, and they do their intervention and it is corrected. I think if it arises now, if it escalates, and child diversion, the officers now are of the view that, this needs to be escalated to a formal warning, then to that extent we can have some recording. But to be frank with you, I don't see the real value of keeping Section 22. I tend to agree with the Senator.
Donovan, thank you for that. Minister, can I just read one thing? And I appreciate my colleagues' agreement with me. But please understand, committee members and colleagues, I am not asking for your agreement. I am asking you to read what the law says. The law says at Section 5, The Child Diversion Office shall be responsible for the rehabilitation of children in conflict with the law and for the development and implementation and administration of child diversion and without prejudice to the generality of the foregoing blah, blah, blah. The jurisdiction of the Child Diversion Office is engaged when children come into conflict with the law. When do children come into conflict with the law? And what are children in conflict with the law? Under the definition of this act, conflict with the law in relation to a child means taken into custody of a constable on suspicion of having committed a diversion offense or detained or charged with a diversion offense. There is no role for the Child Diversion Office under the way we have written this law for the Child Diversion Office to be receiving information about a child who has been informally warned. It is ultra virus to the very act it is sitting in. I am not asking for agreement. I am asking you to read the legislative provisions.
Mr. Chair, might I just, Mr. Chair?
I just wanted to point out, sorry, Chairman, through you, that Section 22 states that where a child accepts responsibility for a diversion offense specified in the first schedule, and in the opinion of a constable, the diversion offense committed does not warrant a formal warning or a police caution, under this act, the constable may give an informal warning. So I don't know if it is that the committee, the members are deciding that this section has to be amended to remove acceptance of responsibility, committing the child diversion offense, because even for an informal warning to be issued, you have to have accepted responsibility for committing a first scheduled child diversion offense.
Chairman,
yes, go ahead.
One step further, if you go back to 21, it speaks of police warnings, police cautions, and referral to child diversion. The side note says constable may issue warnings or police cautions based on the first schedule. This, and I'm reading it because it is important, subject to subsection 2, where a constable has received notice of or reasonably suspects the commission by a child of a diversion offense specified in the first schedule, the constable may, in accordance with the provisions of section 22, 23, and 25, issue an informal warning, a formal warning, or a police caution as appropriate in the circumstances to that child. This is in keeping with the best interest of the child. The informal warning, formal warnings, and cautions is triggered by a child diversion act.
Offense.
It is a child who is in conflict with the law, and a police is given the authority to exercise discretion. So I'm saying we are dealing with children and real lives. That is not. That is what.
Look at the definition of conflict in the definition section.
No,
look at the definition.
Senator Sharon Golden, you can't ignore the fact that the Section 22 is triggered by the child committing a child diversion offense.
No, sir, it is not. Please
could you
please
read it? Where a child accepts
responsibility
for a diversion offense committed, specified in the first schedule, and in
the opinion of a constable, the diversion offense committed does not warrant a formal warning, etc., etc. He accepts responsibility for a diversion offense. I am not quarreling with informal warning. I am quarreling with the fact that the Child Diversion Office receives a record of this offense in circumstances where the officer has chosen not to arrest or detain or charge.
But
that's what I'm quarreling with. Because by creating that record, when the child is formally in the program,
Senator Sharon Golden Campbell. Senator Sharon Golden Campbell.
Sir, I yield.
Please,
okay?
please.
I'm going to yield because I can't explain the law any more than I already have.
What is clear is that an offense has been committed. the officer says, rather than charging the person, I don't want to charge him, but I'm going to warn you. It could be a formal warning or a charge, but they go to the lowest level. Because it is not you have committed an offense, but we are going to refer you to tell your parents what you have done, tell the Child Diversion Committee. In fact, the Child Diversion Committee can take it up, but the point is that it is that gray area that I've been speaking about which is appropriate. So we're going to leave section 22 and we move on, please.
No, you know what, Minister? Can I please request that the Attorney General look at the section and provide us with an opinion?
Not
because
a problem.
I am adamant that it is not appropriate, not legally appropriate for the Child Diversion Office to receive these notifications.
Ms. Messada, could you have a look at it for me, please, and maybe at our final meeting, give us some idea.
Minister, Chair, Mr. Chair.
Yes.
Through you, Mr. Chair. Just to indicate that when I said I'm in agreement, probably I should term it forensically. What I am saying is that having listened to the arguments or the concern of Senator Golding, and having looked at the section 22, I am persuaded that there is merit in our submission. So I just want the Senator to understand that this is not a blind agreement where I am agreeing. I have listened and I was just persuaded by the line of arguments and having looked at section 22 myself. So just to put that on the record.
No, we have not. We can recommit it when we next meet and ask the Attorney General Chambers to give us their views, the appropriateness of this being in the act, okay? I think we're going to take lunch now. Lunch is downstairs. There are also sandwiches. And we restart at 2 o'clock. Okay, we restart at 2 o'clock. And the likelihood, if you don't mind, we could finish up today. So everybody, we restart at 2 o'clock, exactly 2 o'clock. And we have lunch now, sandwiches and lunch downstairs for everyone, okay? So we take a break now and return at 2.